Does anyone have a motion in that regard?
I move to accept the minutes.
Do we have a second?
Second.
And all in favor? All right. Can we ask before, for the purposes of recording our votes, who's present in New York? Oh,
Marvin Schechter, New York City.
are Peter or Barry there yet?
No.
Marina?
It is. We anticipate them being there.
Marvin, who's there with you?
Peter's on his way, I'm pretty sure. Barry is in Australia. Marina's here.
Yeah, why don't you see?
You need me up front to see me? Am I in a good spot for you?
We can actually see you better where you are, I think.
I'll stay right here then.
Do you want me to move?
Oh, just want to know you're there.
All right. I think that's fine, as long as we know you're there. And then we do need to record our votes pursuant to the action we took at the last meeting. So on the first motion to approve the meeting agenda, we need votes from the people of New York.
I vote in favor.
Dr. Stasi, your vote on that issue?
Yes.
Thank you. Our next agenda item is a review and approval of our minutes from our December 8th, 2011 meeting. Do we have a motion in that regard?
I'll move again to accept the minutes.
We did so well the last time.
Thank you, and do we have a second?
The agenda to it.
All those in favor?
Aye.
Aye.
Is there anyone opposed? All right, thank you. Our next agenda item is our laboratory updates and accreditation items. And the first item on the agenda deals with the Westchester County Department of Laboratories and Research Division of Forensic Science. Kathy, if I could turn it over to you for that item.
Yes, yesterday I sent out a binding recommendation letter to all commission members. This is the binding recommendation from the DNA subcommittee accrediting the Westchester County Department of Labs and Research Division of Forensic Sciences in the discipline of biology, which will go concurrent with their ASCI lab cycle through September 29, 2016. In addition, you have that was received in your binders, ASCOD lab letter dated January 25th, granting the accreditation, and this is a renewal of their full cycle ISO accreditation, as well as a certificate of accreditation from ASCOD lab in the scope, as well as a final assessment report. The lab director, Bob Adamo, is here in Albany if you have any questions for him, and also the QA manager, Linda Duffy, is present as well in Albany.
Do we have any discussion on this item or any questions?
I have some questions, Mr. Chairman.
Okay.
Bob, can you hear me?
Yes, I can.
Good. Most of my questions are pretty short and don't need a long discussion, but if I ask you something you don't get it, just tell me to rephrase it. Page 2 of the accreditation indicates that one of the things that the ASCLAD lab people did was they used your own documented management system as part of the assessment. Is that correct?
That's correct.
Turning to page 6 out of 13.
If you could hold on 1 second, we're trying to find it.
Sure.
Which page was that?
Page 6 of 13.
Yep. Yes, I have it.
The top of the page where there's a box marked finding, correct?
That's correct.
And it talks about root causes, corrective action. Root cause analysis was not identified in approximately half of the documents reviewed. And also review of the documentation provided could not determine if monitoring of the corrective actions proposed were ongoing or completed. I've read what your response is and what you're doing. My question to you is this. The ASCLD lab specifications for doing this are not new. They've been around a fairly long time. So my only question is, how did this happen, that this very basic thing was not done, and more importantly, that there was no monitoring of the corrective actions proposed, ongoing, or completed?
Well, first of all, the inspector was wrong. In looking at each of those corrective actions, in order to do a preventive action, a correction, or a corrective action, you have to determine what the root cause of the item was. Our supervisors, who pretty much are the ones who do the investigations, would do a narrative explaining the entire process of the investigation. In about half of them, the supervisors used the word root cause. The other supervisors did not. But the root cause, if you read it, was in there. So we couldn't have done a preventive action or a corrective action unless we knew what the root cause was. So one way that we fixed this was we created a document that now specifically spells out the word root cause, so the supervisor has to fill in that area so it's clear to everyone. Apparently it wasn't clear to the inspectors looking at it. And that was part of the problem. We tried to explain to them. If you look in the narrative, the root cause is explained in the discussion of how the investigation was performed with respect to that specific issue.
So you had it right, but you didn't use the right word, and ASCLD lab's finding was incorrect.
That's correct. Half of the people that were doing those inquiries used the word root cause, and he felt that, well, the other people, if they didn't use the word root cause, were not looking at a root cause, and that's incorrect.
I got it. Let me turn to page 7 of 13, the top box on that page, where there's a bullet that begins with the words, the self-imposed restriction to finish corrective actions within 3 months is being removed. Did you see that?
That's correct. The reason we're doing
Last sentence of, I'm not asking a question about the 3 months.
Oh, okay.
I accept you on that. My question goes to the last sentence. This time frame is too limited for a thorough investigation and when enlisting customer cooperation and follow-up. When you say customer, who are you referring to?
the police agencies or the district attorney's office. So, for example, if we had a case where it involved a case submission, we would have to get information from, for example, the police department or from the DA's office. And sometimes it's difficult to get information from investigators. They're not on the same cycle you are. They leave at, they come in at 4 o'clock, we leave at 4 o'clock. So it's difficult sometimes to get in touch with people to get all the information you need to finish the investigation. And so what we felt was we had originally had a 3-month time limit to get the investigation over with. And in our discussions, we felt that, you know what, that's not really useful, because sometimes you have to look at a lot of reports, you have to interview a lot of people, and it puts a time constraint that's really not very effective in getting a thorough investigation. So what we decided to do was to suspend that and to make sure that at every senior staff meeting, we have them once a month. We actually have an agenda item that's permanently on the agenda where we have to discuss every open quality issue, and each supervisor who is responsible for each investigation has to discuss each and every one of the quality issues that are open and why they're still open or what's ongoing with them. That will allow us, instead of having to worry about a 3-month period to look at something, we'll know every single month where the status of that investigation is, and do we need to speed something up. For example, for me to make a call to the DA's office and say, hey, your DA has not gotten back to us, we need this information to finish this investigation. Or maybe call up the police chief and say, you know what, this investigator is just not getting back to us, we need this information. So that's being discussed at every single staff meeting now.
On page 9, Bob, of 13, of the report, there's a box marked finding, and the second paragraph of the box begins with the words, "The laboratory has declared that the electronic chain of custody is the official chain of custody." As it turns out, and you'll correct me if I'm wrong, crime scene evidence that was being collected at a time certain was then handed over to the lab, and the lab recorded that as the time of collection. Am I correct?
No, what was happening was this pertained specifically to vehicles that we were getting in the laboratory as evidence. We were treating the vehicle as a crime scene because many times we will go out to crime scenes and the only crime scene is actually a vehicle. So we felt that when we got a vehicle into the laboratory, we should treat it as a crime scene. The way our LIMS system is set up, we have what's called a team leader. The team leader is the person responsible for the input of all the evidence into the LIMS system. When individuals were collecting evidence, they were writing down in their logs the exact time and date of the collection and who collected it. So with respect to chain of custody, that has always been maintained. It's never been broken. It's just kind of a quirk of this LIMS system that only one person is allowed to put in all the information about that specific case that you're working on. So that was the problem. He was looking and seeing that the team leader was responsible for entering all these chain of custodies, when in reality there were several people who had actually collected the evidence. But in terms of our paperwork, the actual paperwork that was done concurrent with the person collecting the evidence, that chain of custody is unbroken. The time and date and the person collecting it was recorded.
So as of today, if I were to subpoena the Beast records for a particular case, and I looked on the record from your lab, I would see the time that the particular piece of evidence was collected by, for example, a police officer at the actual scene of the crime.
What you would see if you subpoenaed our records is, for cases prior to this time, you would actually have our crime scene records, our paper records generated by the person actually collecting the evidence, indicating the date and the time and the person collecting the evidence. Now what we've done is we've changed it so that if we go out to a crime scene now, say we go external to a crime scene, everyone who collects evidence now has to sign that over to the team leader so that we don't have that problem anymore. So the team leader, when they enter the evidence into the LIMS system, they actually have possession of it both from a paper point of view and from an electronic point of view.
And the original documents, as it's indicated on page 10 of this accreditation report, the top of the page, in the paragraph beginning the handwritten forms, it says the originals will be filed in the case jacket.
That's
By
correct.
case jacket, do you mean the case record?
The case record, the thing that's turned over during discovery,
To the DA.
whoever asked for it.
Well, if I asked for you in Westchester, if I asked for the case jacket or the case record, you will turn it over to me and it would have these originals in it.
Yes, it would. It would have copies of the originals.
Okay. Let me just turn to page 11 for a moment. I think you've solved this problem. There are two instruments that you used to have at your laboratory called Capillary Electrophoresis instruments. There were two models, the 3130 and the 3130 XL.
That's correct.
And there seemed to have been there was a problem in using two machines, one to test the reagent and one to test the actual forensic sample.
No,
Apparently this has been eliminated, correct? You got rid of the second machine.
well, let me explain what happened. What happened was
Sure.
the samples were run on one instrument, and all the controls were run on that instrument. Then, for whatever reason, and I'm not sure what the reason was, we had to rerun some of the samples again. And instead of rerunning them on the same instrument, they were run on the second instrument. However, one of the controls wasn't run on that instrument. And according to the QAS document, you're not supposed to do that. Now, part of the confusion may be, they say different models. This is essentially the same model with a slight difference. It's not like it's not a different platform, it's not a different type of instrument. It's the same exact type of instrument. The only difference is there are more capillaries in the XL than there are in the 3130. So it was just a slight oversight. It didn't affect the cases. The controls were run. The controls The negatives were negative, the positives were positive. It's just that when they were rerun on the other instrument, not all the controls were run. Because they've been
Bob, thank you very much.
We should note, it appears that Mr. Neufeld has joined us in New York, is that correct?
Mr. Scheck. Scheck and Neufeld are here.
No, Sheck's in Australia. He has, because Barbara said so.
Apparently he's not.
Michael, for your edification, those are two different people.
That was a quick flight back from Australia. Welcome back.
Thank you very much.
Is there any other discussion or any further questions with regard to Westchester?
I would like to follow up on the reagent. Yes. As I understand, your SOP did not require the injection of reagent on the second instrument.
The QA manager from
That's what the statement says here. That the QA manual will be revised to include excuse me, guidelines for repeated samples of instruments.
Yeah, that was a new requirement when the QAS audit document was revised.
So-
The controls were run, they were required to run it at the same amount of time, and that was done. It's just that for whatever reason, they didn't realize that the XL was a different model.
My question is, Accreditation Lab, they do have a standard for standards and quality control and analytic runs. To what extent do they describe the requirements for the design of those controls and standards?
Well,
Again, you were operating by your manual.
yeah,
You
well,
accept
controls were run on that, when those samples were rerun, controls for that particular instrument were run. It's just that the extraction control for those particular samples was not rerun. Because it was never the first time.
Correct. But you were operating by your SOP.
Yes.
As that lab discovered or back at the time of inspection stated that it requires the second injection.
It's actually the FBI, ASCII lab, does not require that.
Oh, so it is an FBI requirement.
It's
It's clearly
FBI
stated that it is
DNA.
required.
Yes, but when they revised it, they specifically said different models.
Okay.
And when we proposed our corrective action to the FBI, they were in agreement that it was proper.
Because as we move on and discuss accreditation program requirements, many of us have made a point that, yes, there are standards of practice, but often it's not very clear what the requirements are to meet those standards. And it is somewhat unfair to laboratories at the time of the inspection to be cited for a practice where, in fact, the accreditation program did make clear that that was the requirement for compliance with the standards. But in this instance, it does sound as though the requirement was existing.
Well, it was a new requirement.
A new requirement. All right, thank you.
All right, any further discussion or questions with regard to Westchester? We don't. Do we have a motion to award New York State accreditation for the Westchester County Lab?
I make the motion.
Do we have a seconder? We have 2 seconds? All right, we have a second. All in favor?
Aye.
Anyone opposed? Is that one opposition?
That's correct.
Okay, thank you. And that passes, and Westchester is awarded New York State accreditation. Thank you, and thank you for coming. The next item on our agenda is the Nassau County Medical Examiner's Office, Division of Forensic Services. And again, Kathy, if I could turn it over to you for initial report.
The Nassau County had an extension of scope request at the last meeting, and they were granted provisional accreditation from the Commission for latent prints for a period of 6 months. ASCII Lab came into the laboratory and had an inspection on January 31st to February 2nd of 2012. And in your binders is the result of that inspection. This is still, there are a number of issues that need to be addressed prior to getting accreditation. Those issues, they had 10 level 1s and 1 level 2 corrective actions regarding latent prints. It should be noted that the laboratory is not actually working real actual cases at this point. They worked on mock cases, and a lot of the problems might have been related to the fact that Accreditation did not have sufficient casework to review when they came in. So they've only worked on mock cases, as I said, and any sort of verification cases they received from the PD that they did technical review on. We do have available for to answer any questions. We have Karen Dooley, the Assistant Lab Director, Mark Field, the QA Coordinator, and Jennifer Hannaford, Latent Print Supervisor. They are in New York City. And on the phone, I believe we have Pat Buffalino, who's the Director of the laboratory. He's recovering from shoulder surgery and is not able to attend the meeting at this point.
Hi, Kathy. I am here.
Oh.
Thank you.
Kath, can you guys hear me?
Yes, we hear you.
Okay, great. Thank you.
Do we have any discussion or any questions with regard to Nassau County Medical Examiner's Office?
So in light of the open issues and the request from ASPAD Lab that a minimum of 6 additional cases, 3 per analyst, there being 2 analysts, be developed for their review prior to any decision, I presume we're being asked to continue the provisional accreditation pending those materials being available, the corrections being made, and ASCLD revisiting the issue?
Well, the provisional accreditation stands through June of 2012, unless something different happens. But it's my understanding that Nassau would be starting to look at actual casework in April, and therefore, when ASCLD Lab returns to look, they would have sufficient casework to review at that time. And generally, ASCLD Lab likes to see 90 days worth of casework in order to get to make an adequate review.
Well, this gets back to the issue of our review of provisional accreditations and the discussions previously being what did that mean and what should labs be doing and how do they inform their customers, DAs and police departments, that they don't have accreditation. They're working in this gray area of developing protocols, and the recommendations, I believe, that the Commission has repeatedly made, that means you don't do real casework, and now that ASPAD Lab is going to accept mock casework, why would Nassau be moving on to real casework in April when, as we see from this review, there are major issues about their ability to do that yet? And so shouldn't these next 6 really continue to be mock cases until the issues have been addressed to ASPAD Lab's satisfaction?
So recall that the Nassau Lab was the last lab to receive provisional accreditation, and it was not until after they were voted on that the issue came up that we weren't going to continue provisional accreditation. So
I agree, but in light of the findings of ASPAD's visit, which was rushed, as I think our request and Nassau's request, in an attempt to get this lab moved to the next level, they're not ready to move to the next level. And the issues that have been raised in this report suggest that the staff didn't understand the technical review processes, that record keeping was incomplete. I agree, because they're mock cases, that may explain some of the missing documentation because they're not complete cases. Some of the other things wouldn't have been there. But I, for one, am not convinced that they're ready to do real cases, particularly in light of longstanding history of the county, not necessarily this lab, not necessarily this personnel, not necessarily this lab director, but it remains an open issue.
I'd like to just say a couple words. So basically, our intent now at this point, and we had the option to not go ahead with the assessment, but my feeling was, since we're not doing casework, I thought it would be best practice to have ASCLAD and have Bill Smith come in to do this assessment so that we knew where our shortcomings were before we could begin casework. We've made those remediations, and the next step, as far as we're concerned, is the ability to give them true cases. Now, I'm not speaking for ASCLAD Lab, but my feeling is the extension of scope and mock casework is definitely not the right avenue to go in terms of putting on a new discipline. I truly believe that what we offered them wasn't sufficient. What the work that the auditors did for us, they did point us in the right directions in terms of charting. We had, in terms of the chain of custody issues, we were in flux with our LIM system where we had certain bugs where it worked, then it stopped working. So unfortunately, that's my fault. I should have had them, and I should have checked for these manual chain of custodies. The majority of the criteria, in my feeling, are administrative issues, which we resolved and have already sent back our remediation document to Bill Smith and John Nooner, and they've approved it with the caveat that we'll be sending them cases within the next 3 months and then have them back in sometime after that third month to come and finish up their inspection. I know the 10 looks like a lot. It's a new lab that was put up. There was a lot of chaos during that period, but I truly believe we have an excellent work product, and that was out of the mouth of Bill Smith, who said, look, you have 10 findings, but you have the start of a solid program. So I'm hoping that the commission will agree that the only way to go forward at this point is to allow us to do casework for the 3 months, show that we can do this, show that our SOPs are now up to date, and allow us to get some feedback from ASCLAD after the third month.
I have a question here. Looking at, let's just take number 3 here, where there's an examination of records documenting latent print identification consisted only of whether a level 1, 2, or 3 detail was used to make the identification. The information used to make the analysis and comparison was not identified or indicated sufficiently to allow another reviewer the ability to evaluate what was done and how the examiner came to his or her conclusion. Now, that's not a chain of custody issue. That's an issue of what you actually produce. And based on the standard operating procedures that we reviewed in the last session, that's impossible. Because under the standard operating procedure, you're supposed to actually have the latent and the target, right, or the known. You're actually supposed to be drawing on the latent before you look at the target, the various different minutia or rich impressions that are going to be the basis of the identification, whether it's a level 1, 2, or 3. And that's all got to be preserved for somebody else to look at, a supervisor, to bring it to court. I don't understand, obviously I don't have, the casework or anything in front of me, but I don't understand how that can happen, that given the SOP you showed us. So that's point number 1 that just puzzles me. Point number 2, in our discussion with you with respect to protocol, I personally went to some great length to make sure that you guys could have access to the FBI's new standard operating procedure that was implemented after the Mayfield case that tries to deal with a lot of these issues and that we discussed in that last meeting. And my question to you is, A, have you been able to get them? And B, will you implement?
Barry, the answer is yes and yes. Jen, I'm going to let you speak after. I'm going to, one more sentence, and I'm going to let you speak, because I do believe we were charting but prior to this, and I'll let Jen attest to that. But at the same time now, we've kind of upgraded it to what the technical assessor was looking for. We had discussions with John Nooner back and forth, and I believe now that the way we're charting is more than adequate. But I'm gonna leave this one for Jen because it's a technical issue.
I'll address the FBI protocols first. We did receive them. We have included some of those in our protocols. One was a suggestion I believe you made when we first approached the commission about APHIS hits and having...
About what? I'm sorry.
Automated fingerprint identification system hits. We will have a third party review cases when it's a single hit. As far as documentation goes, the standard reads, examination records do not have to provide detailed description of the thought process involved in the analysis, comparison, or evaluation. However, examination records shall include which prints were analyzed, compared, evaluated, and conclusions reached. Examination records shall also acknowledge the existence and disposition of any captured latent prints which are not analyzed, compared, and evaluated. We were meeting that criteria. However, the two inspectors had talked to us about the review process and said, how do you know which specific points the other examiner used? And we said, there's separate analyses. The latent and exemplars are available. However, in the case of identifications, which they pointed out, at this point, going forward and part of our remediation plan, we will include for the case record documentation, annotations for identifications that are not given to the other analysts before they make their own analysis of the print, and they will be made available.
I'm just confused about that because that very criteria which you just read us, that your SOP had in it that the thought processes of the analyst did not have to be included in the report, was one of the specific things. I don't know if our minutes reflect this, but as one of the specific things that I called to your attention as being troubling and being different than what I understood to be what the FBI was doing at the suggestion of the Inspector General of the Department of Justice after the Mayfield case. And I think it's fairly simple. As I understand it, that what's supposed to happen is the fingerprint analyst takes a look at the latent, and when you see the latent, if you identify rich flows or minutia or level 1, 2, 3 characteristics that you think are going to be significant, you circle them and identify them. In addition, if you see any discrepancies, what the FBI calls red flags, things which you think might be artifacts as a result of the way the latent was laid down, you circle those as well. And then and only then does the analyst go and take a look at the known. And then if any additional points for identification can be used, that after looking at the known print, those would also then be identified as changes. And if that's true, then what should be available for somebody else to review is exactly what was circled in the first instance, exactly what on the latent, and exactly what should be on the known. And that's the whole point of this process. So, and that would reveal, of course, the quote-unquote thought processes of the analyst in deciding what points are going to be used for making an association. I won't use the word match. Hope you don't. So I don't understand how. So are you going to be following those processes now?
We have expanded our worksheets, even though we would document if we felt needed distortion or other items that should be looked at during the analysis phase. We've expanded our worksheet to include that, but that doesn't necessarily mean you have to annotate it on an image of the print. We will mention what...
Could you do that? Why can't you do that? Why can the FBI do that? Why can't you do that?
We just don't do it. I don't feel it's necessary in every case. It may be necessary in the more difficult prints. When you have a straightforward print with clear quantity and quality of detail, we would go on to the comparison phase. The analysis of that print is captured in our worksheet.
Barry, the bottom line is at this point now, both digitally and on a worksheet, we are making those annotations. So that was part of our remediation after ASCLD left in January.
So when you say only in some cases, you're meaning only in the ones which you consider difficult, not the ones that you don't consider difficult. Is that it?
Annotations may be used by the analyst when they determine that it's necessary to analyze the print further if it's not straightforward. However, annotations will be used for every identification that is made.
But what about the cases where you don't make it? What about the cases where it's considered, quote unquote, inconclusive? I think one of the things that we discussed last time, and one of the issues in the area of fingerprint most importance, is that, and we saw this in the Phyllis Martin case with the New York City Police Department, resulted in hundreds of re-examinations, which I'm still not in any way convinced we were ever able to go back and look, is that what about a false exclusion? The recent black and white box studies that were performed in the National Institute of Justice, they found a very substantial rate of false exclusions. And, that's a problem.
I understand.
That for a prosecutor, you're letting the guilty guy go if you've got a false exclusion, and you go pick up somebody else that didn't commit the crime. So, I don't understand a policy that does not require, in every case, the annotation of the actual image before you look at the target, and then for the documentation after you look at the target. And I don't mean to pick on you. I'm hopeful that Nassau County can make lemonade out of this whole situation by following what, from a cognitive psychology point of view, is a better way of analyzing. Everybody should be using that protocol. That's why we went to such great lengths to get it from the FBI, and it was distributed on a confidential basis so that every lab in New York can take a look at it and every single one can implement. We should at least start with that.
I might point out, though, for exclusions, we do note why there is an exclusion, and sometimes the explanation on our worksheet is better. I know not everyone is a fingerprint examiner here, but quite simply, you have class characteristics of loop, arches, and whorls, to make a simple example. If you had, say, an individual whose exemplar prints were all whorls, and you had a clear latent that was a loop, it will suffice to state in your records, in the case notes, this is an exclusion based on that characteristic. And annotations, even the written word is probably more descriptive than going in and trying to draw a loop out versus...
You don't have to circle for an exclusion like that. You wouldn't have to circle all of them. You could circle a representative sufficient to make which I think is required by these protocols.
And in our sheet, we do say, all 10 fingers were...
I'm just saying it's not an enormous burden to actually draw it on the latent and on the known, saying here's two of these minutiae or whorls or ridge impressions are sufficient for us to say this isn't the print, and here's the 2 or 3 that we've already circled to say that it isn't. And you can produce that rather than just simply describe it.
And within our notes, we do include the exemplar as well as an image of the latent, and we would say fingers 1, 2, and 5 were eliminated, and you have both records to go to.
But they do say that, I'm reading this one thing, they're saying that's what they were criticizing, that they just simply say, here's the level of detail that we looked at, and then they say the information to make the analysis comparison was not sufficient for another reviewer to evaluate it without doing the whole thing over again.
To make an identification is what it says.
Kind of exclusion too. Same process.
A couple of questions.
Yes.
So, did you say that the analyst may document the reasons why she or he decided that there were similarities, but they need not?
They may choose to use annotations. They do have to use their case notes to document everything. But as I was explaining before, We are requiring annotations for identifications, but if they feel there's a case where annotations would better explain the exclusion process, that they may choose to do that.
But in the match, I'm sorry, you say it has to be documented notes, but does the process have to be documented in the notes?
For the identification?
Yes.
You explain the pattern type, the class characteristics, and it is noted it's an identification and what finger.
But not why you decided it was an identification. Not the basis, I'm sorry, not the basis for deciding it's an identification?
Well, the annotations now would show which points were used.
And to the extent more any kind of discordant data, is that required to be notated?
We certainly wouldn't ignore it, and if it did exist, it would be noted, and if it was unexplainable, it would not result in an identification.
Is it mandatory, though, that that be explained by the examiner whenever they see any kind of distortion or anything else that superficially might create?
That is included in our notes now, yes.
But that's
in the written notes.
That's a specific in the FBI protocol. It says you have to circle and identify every potential artifact on the latent before you look at the note.
They do that. We are not going to do that in this case.
Sorry?
We do not do that because the record is available there to look at.
No, that's not acceptable. I mean, what is just not acceptable? I'm sorry, I don't need to be offensive about this. But why is the federal government and the FBI that's dealing with terrorists going through this whole procedure, and after all the scandals we've had in Nassau County, you're not going to go through a process where you first identify what's a potential artifact? That's exactly the reason.
Barry, I think what Jen has said a couple times now is that it's going to be represented in the note. It's just not going to be annotated unless they feel that there's a necessity for it. I think what we do here is quite a bit more than some of the, and I'm not trying to throw anybody else under the bus, but what we do here is probably a lot more than what the other labs have been doing, because this is something that ASCLD basically demanded on us during this inspection. Right. So our feeling is we did move in the right direction. We're going to annotate all the identifications, and in the note-taking portion of the negatives, now Jen, correct me if I'm wrong, but there is an explanation as to why there's an exclusion for that particular case.
No, we were talking, Pat, about artifacts, and I completely agree with you that what you're doing here is probably more extensive than what we're doing in the other labs in New York City. But that is not acceptable. Now, I sat here and I read all these criticisms of the Inspector General by people in the labs and of this commission saying that, gee, people from the disciplines are not here represented, and we have no ability to comment on what you all are doing. Well, that's nonsense, because we had the Justice Department go through this report. And I want to remind you all again that there was a man in Oregon that was accused of actually doing the bombs in Madrid, okay? And the Spanish authorities said that's not his print. And the lesson learned, and the reason the Spanish authorities said it's not his print, we see these things that are discrepancies. And the Federal Bureau of Investigation said those are not discrepancies, those are just the artifacts you get from rolling every time a print is rolled down, okay? That is a major, major scandal.
Okay, so what do you...
The government
wait a minute. One person...
The government said that you have to do these...
Barry and Pat, wait a minute here. Barry and Pat.
Yeah.
I think what we need to do, we got both of you talking at once and we can't follow it here. I think what we should do is finish with the questions. If you have questions for anyone at Nassau, let's get the questions out of the way first, and then once the questions are done, if there's any discussion, I'll open it up for discussion among the commission members. But we got both of you going at once, and we can't hear anything here. So let's finish the questions first. Does anyone else have any questions for Nassau?
I do.
I do.
Pat, it's Kathy Corrado here. I wanted to ask
you about,
hi. I wanted to ask you about the finding, I think it's number 6 on your remediation chart. And I guess what I'm a little bit confused about, I mean, I agree that a lot of your findings were administrative, and this one seems to be as well, talking about the furniture. But I guess what I'm concerned about is it seems to imply that you had furniture in place in your laboratory I'm assuming it means desks and other types of computers, things like that. And either during the inspection or right before the inspection, the county pulled all that furniture out, and then when it became an issue in the inspection, they brought it back. I guess I'm a little concerned about, is your county supporting this laboratory and bringing the latent prints into the laboratory? Is it really supporting that? Do you feel like you're getting the support you need from the county in terms of funding and just this kind of thing? I don't understand why furniture would be removed prior to an inspection if they're really supporting you.
All right, so let me explain what had happened, and it really stems back to this qualified or qualifying agency status. At the time, there was a thought that the amendment would not go through, and what happened was the county executive made a decision to move the furniture that was supposed to house the safest or safest equipment. It moved that from us back to the police lab because we didn't have we didn't have qualifying agency status. So what happened was a decision was made, Department of Public Works came by, picked the furniture up, brought it to the police laboratory, and then what happened was, I believe, the day of the inspection, we had clearance from the ledge that gave us qualifying agency status, and it was brought back the day of the inspection. But unfortunately, the auditors went in, didn't see furniture, and wanted to know where our work was going to be conducted, and we had to explain what the issue was. It was out of our control. In terms of support, we just got approved to hire 3 people. Their paperwork is in with civil service, and we're now working on an additional 3 people. So there is support from the county executive at this point now, trying to get people into this laboratory to get going with the confirmations, and at the same time to go forward with processing.
But their first reaction when you didn't have this qualified status was to immediately take the equipment out and put it back to the PD. Is this the issue that's going to be if they decide they don't like the way your lab is doing something? It's just going to be pulled back and sent back to the PD? I mean, do you have a feeling for that?
Kathy, I don't have an answer to that question. My answer is I would hope not. I don't. I mean, even speaking to the one of the chief of police, I don't think there's any thought of this discipline going back to the police laboratory. So I'm going to backtrack a bit and say no. I don't believe that that's the intent. I think that now that we have the qualifying agency status, I think that opened up the doorways to try to get people in. There was a fear that we weren't going to get this, that there was it may have been kind of vetoed and it wouldn't go through the floor, but it went through faster than we thought, and as soon as that went through, the hiring began, or the process of hiring began.
Richard Jennings. It's my recollection from last meeting as we were voting for provisional accreditation, we were told that the mock cases had in fact received informal review and found to be acceptable. Now in this report we seem to have fundamental flaws and fundamental practices. How is it that last meeting we're told mock case is okay and now we find not?
Well, I mean, and again, this is my opinion, and I'm not speaking for ASCLD, but I don't believe 5 mock cases is a good method for a laboratory to work out their kinks. Coming from the auditor himself, I guess there was a feeling that we were about 3 months too early with this, and we were given the opportunity to say, all right, look, come back in 3 months and do this. My feeling was no. I said, I don't care if I get 100 criteria marked incorrect. I would rather have guidance from ASCLD Lab to find out where my shortcomings were and improve on those before we accept our first case. So I truly don't believe that, and again, my opinion, and I don't know if Karen has the same opinion as I do, but I don't believe 5 cases is close to being efficient enough to test the laboratory's operation.
But with 5 cases...
But I'd like to point...
Go ahead.
I'm sorry, that you broke up. Hello?
I was just going to point out that, there were some of the administrative issues, the chain of custody with limbs not being up, but as far as your comment about the mock cases being fine. We did meet the correct answers for the analyses that were done on it. So I just wanted to put that part forward. So excuse me for interrupting there.
Yeah, thank you, Jen. What Jen is saying is that we weren't even able to complete the entire inspection. A lot was NA because we just couldn't show our productivity with the 5 mock cases. So if you look at the inspection report, you're going to see quite a few NAs.
Well, again, the 5 cases, I would think that you would ensure that everything was in place. Looking at citation 9, the page isn't numbered, but it stated that in each of the case records reviewed, 10 mock cases and 4 casework cases, the chain of custody record was checked off by the technical reviewer as completed. None of these cases had a complete chain of custody. Again, a fundamental flaw.
That's correct, but the chain of custody was in the LIM system. It just, we didn't have a hard copy in the case file. When we applied for provisional accreditation, our LIM system was tested, everything was fine, we went forward, and unfortunately, and I'm not sure, I know I discussed this with our DA's office, we had quite a few bugs with the LIMS program, and that's since been corrected. We have proper chain of custodies, we have proper evidence tracking, and again, I'm at fault for this. There's no excuse for not having a paper chain of custody. That's something that is just not going to happen in the future. We're tracking evidence submissions to the labs electronically. We're tracking evidence transfers within the examiners in the laboratory electronically. So I believe now our LIM system is where it needs to be. The bugs were resolved, I believe, a few weeks back before I went away. And I truly believe that the problems that you've seen that were chain of custody issues are not going to be seen once we start casework.
I would just like to add that.
I'm sorry. Please repeat that.
I'd just like to add that we're talking about believing it. We did issue new competency tests to both examiners, not only to give them the competency test again, but also to test the process, make sure the chain of custody was working, make sure that we were documenting things the way that they were documented and that all these issues were remediated. So it's not just that we believe it's fixed, we've tested it and feel that it is fixed.
Well, I'm very sorry to say this, but these citations and responses are quite reminiscent of the FBB citations and responses. I'm not quite certain that these root causes have been identified. Again, I asked the question, why fundamental flaws in fundamental practices? Competency assessments, not compiling records to the extent that there could be an independent review, anticipating the expectations of the accrediting organization in the presentation of chain of custody documentation. Again, these observations raise real concern whether aside from being pressed for time, that the expertise is there, fully understanding what the accreditation program requirements are.
Could I say something about that, Richard? I don't know if that's fair. Pat Buffalino has run this lab, I think, very, very well. And although Nassau is entitled, to compare him to what we were subjected to for 8 years regarding the other Nassau lab, I don't think it's fair. I think what we have to remember here is we're talking about fingerprint analysis. And correct me if I'm wrong, someone who has more knowledge than me, but I don't believe that there are more than 3 or 4 labs, Gina, in the state that are accredited to do fingerprint work. I don't know if that's an accurate number or not. And I'm listening to Barry, I understand Barry's concerns, and aside from number 3, I think the 11 corrective actions are mostly administrative. And Mr. Buffalino or Dr. Buffalino has indicated that he's addressed those, and his past history with this commission suggests that he should be believed on that point. And I think that we shouldn't give blanket accreditation to any lab, but that we certainly should be supportive of this lab in light of what they've gone through physically, and in light of what we should be doing to encourage fingerprint examiners to be accredited. I just finished a murder trial in Syracuse where a series of fingerprints were analyzed by unaccredited people and nothing was found. I then, in preparation for the trial, asked accredited latent fingerprint examiners at the Forensic Science Center to examine the same material, and the killer's fingerprint was found about the size of a dime on the car door of the getaway vehicle, exactly where an eyewitness said he touched that vehicle. And that's the difference, I think, because the overwhelming majority of prints in the state are examined by unaccredited police officers. And I agree that Pat has some work to do here, but I, for one, am going to vote to continue the accreditation and re-examine it very, very carefully in the very near future to see what they do with real cases.
Mr. Chairman, I have a question in New York.
Yeah, I think we
may
have.
I proceed?
Dr. Wiley had the floor, and then as soon as she's done, you have it.
Thank you.
I absolutely agree with you, Bill, that we need to encourage accreditation of entities that perform print analysis. And we may at some day want to revisit the statute and deal with that issue. I would also encourage Nassau in the transition of these forensic disciplines to what has always been an excellent DNA lab that's now taking on these other responsibilities. I have no problem. Their provisional accreditation lasts until June.
Right.
Presumably between now and June, they will perform more analyses, and an ASPIDE lab will be satisfied that these corrective actions have been put in place. My only concern is that I don't believe they're ready to take on real casework unless that real casework is tested in parallel by one of those other accredited labs, and that there would seem to be no disadvantage to their continuing mock casework for the purposes of performing the additional 6 cases that ASCLAD has asked for. I don't know how many they've done. ASCLAD only looked at 4. Half of them had serious problems. So letting them to continue through June, do the additional 6 cases, but that I'm not convinced they should be real cases yet. And that then gives ASCLAD lab the opportunity to come verify problems have been fixed, and lab moves on. I do think the name and the title of the lab does subject to them, unfortunately.
I think of it this way: it's Buffalino, not Grinnell.
And I wholeheartedly agree, but.
Let me just have one procedural clarification before I turn it over to you, Marvin. I don't believe that there's a motion on the floor yet with regard to this lab, and I'm also not sure under our rules, I think it's 9 New York Code of Rules and Regulations, Part 6190, that there would even be a basis for a motion given the provisional accreditation. With that said, Marvin.
Great. Pat, with respect to the letter that you wrote dated February 29th that reviews the 11 corrective actions, I had some questions for you and Ms. Dooling with respect to items numbers 4 and 5 about competency tests. Here's my specific question. First of all, where did you get the competency tests from?
Well, the competency tests that were presented to the audit team, not the audit team, the competency tests that were done here we got tests from the Westchester Police Department, and we also got competency tests from Dcjs. So they were old proficiency tests, but they weren't, we didn't make the examiners aware that they were proficiency tests.
Okay. Second question is, with respect to number 5, it said that there was a minimal passing grade for the written examination will be 80%. Can you tell me a little bit about how you score that particular test? So, for example, if there's 10 questions about latent prints, and on 3 of the questions I, the person being tested, say inconclusive, and on the other 7 I say match or no match, what happens to the inconclusives? How does that figure into the score?
Are we talking about the written test or the competency test?
Either one.
I think what we're talking about is the written test. Jen, why don't you discuss the format of the written test and how it's graded and how it's scored?
Right. Sure. There's 2 different tests. The written test has answers to it that there's only one correct answer. We had to get 80% correct on that. The proficiency or competency test is different in that those are actual latent prints that need to be compared and a conclusion made. So we perform correctly on that test.
What does that mean?
We know the results prior to
Sorry.
administering the test.
We didn't, but
I would
the
know
one who
the
submitted
results
it.
prior to submitting the test to the examiners.
Okay. So what happens if the examiner on 3 of the questions says inconclusive? That could be a wrong answer?
It could be acceptable.
It could be acceptable?
It could be, depending on the quality.
Let me be. I don't want to couch this in cross-examination because it's not that. But the reason I'm asking it is there's been a lot of literature about this testing business and about how it's scored and how examiners and labs get around the system by particularly technicians who are being tested and they know their job's on the line, so they simply say inconclusive because they don't want to get a wrong answer. And by saying inconclusive, they take out of 10 questions, they take 3 and eliminate them. And so now the test is based upon 7 questions. And of the 7 questions, the person gets 4 right, 3 wrong. They pass. They're proficient. Is that what's going on? In your lab? Is that what's going to happen? Or are we going to change that?
I don't believe that's happening now. Mark, why don't you explain? I don't believe that we have the option of just saying inconclusive just to be safe. Am I getting this right?
What are the options that you have as an examiner on the latent print test?
So for the latent print examination, there's identification, exclusion, and inconclusive.
Those are the 3 answers?
Correct.
Okay. So if you answer inconclusive, right?
Right.
But you know that the real answer is match.
Right.
Then that counts against the person, correct?
Again, an inconclusive statement isn't wrong because there's different thresholds with latent print examinations.
Right.
A certain laboratory might have a higher threshold than another one. So we're just basing the results to our results. And certainly, I would hope that if another lab identified a print, that our examiners would make a similar conclusion. However, there may be instances where the threshold wouldn't be enough for them to feel an identification was necessary, so they might report it out as inconclusive.
So let me just further clarify to make sure I understand it.
Sure.
You're administering a test
Correct.
at your lab on latent prints.
Okay.
You go over the test beforehand.
Yes.
You. And you conclude, here are the answers to the 10 questions.
Well, the answers are provided to me from another agency.
Okay, so let's say question number 5, provided to you by the other agency, is non-match. It is not a match. The person being examined says inconclusive. How does that get scored?
It would still be an acceptable response.
It would be an acceptable response.
Correct.
By the examiner.
If the original analyst and the verifying analyst both come to that same conclusion,
right,
then it would be an acceptable response.
Even though the person providing you with this test came up with a different answer.
Well, the person providing the test may know the ground truth and that it didn't originate from that set of people, but it doesn't necessarily mean the quality and quantity of information in the actual latent is sufficient for the analyst to come to the conclusion of exclusion. The person providing the test does. So it doesn't necessarily mean it's a wrong answer. And I think it's fair to say that Dcjs puts a test together where any trained analyst within probably their level 3 course should be able to come to the correct conclusions on these tests. So, I mean, we expected that we would get all the identifications right, and in this these tests we did.
I would also like to clarify that it's not 2 prints they're given, it's about 11. And I think that an analyst saying, oh, inconclusive for 11 prints to stay on the safe side, that wouldn't,
No, I wasn't even positing that scenario.
Right.
I'm positing the scenario where the analyst uses inconclusive to hide and get away from giving an answer so that it isn't scored wrong and he loses his job. That's what I'm really after. And what I'm hearing is it doesn't matter what the correct answer is, correct in quotes, from the organization providing you with the test. If the answer is match, but the examiner in your lab says inconclusive, then that can be an acceptable answer.
But it all depends on, we did this with, Jen, with Boston, with the cases that they gave us. Once the exam is completed, there's an open discussion with the provider and Mark Gill to discuss, because we did have one situation where we had an inconclusive, where I do believe that Boston had a match. And Mark, did you not have a discussion with Boston, and then basically we cleared it up? The one thing that I found with latent prints is that there is a lot of, well, look, just because this person makes an inconclusive, makes this conclusive. I think with the SOPs that we've provided are geared towards, being a little bit better on that. I don't think Jen and Andy are examiners who are going to say, hey, look, Jen and Andy are not in that position where they're feeling that they've got to, come up with an inconclusive because they're in fear of their jobs. I mean, we had somebody 2 commission meetings ago that lost a piece of evidence, and they came to us within 2 minutes. So I think we have open lines of communication here to deal with these particular issues. But again, is the way that the discipline is, you talk to other laboratories, and, from the police lab themselves, we had sent some work out to another agency to verify what the PD lab was doing, and I'd say a good 50% of the ones that the PD said were inconclusive were conclusive, but the examiner in California said, but that's okay. I need that examiner there to basically go over this with them. Now, I don't agree with that, and I'm hoping that with discussions with Twig and everything else, that we can kind of maybe funnel this a little bit better so that there's a little bit more of a workflow or a flow chart that enables you to make these conclusives, inconclusives, and so forth.
Let me just,
One correction
I'm sorry.
on that. I'm so sorry to interrupt you, but Pat, not to correct you, but I think it was stated that there was an identification that was called an inconclusive. It was actually a non-match. Someone called a non-match that we called an inconclusive based on no pattern type, which would be that information we write down that it's not sufficient. We felt we're a little conservative when it comes to not calling them based on a pattern type if it doesn't exist, and we chose, we need not.
There's a lot of room for decision making here, right?
Yes.
Because of the
Yes, there is.
subjectivity of the subject.
Yes.
Right? I just want to be sure we're all on the
You're
same
right.
page.
Absolutely.
Okay. Let me ask you, Pat, let me just turn my attention to item number 9 on your letter of February 29th, where in the first part of the box where it talks about what was found, it says one of the listed components is a checkoff for a chain of custody review. In each of the case records reviewed, 10 mock cases and 4 casework cases. The chain of custody record was checked off by the technical reviewer as completed. None of these cases had a complete chain of custody. Now, let me just finish my question, and I'm willing to hear the answer. First, I would like to know, with respect to what I just asked you about checking off something that is not true, if you consider that, number 1, an administrative problem. Number 2, how does something like that happen in a laboratory? For those of us who don't work in labs like me, I have to fill out a form every 2 years as a lawyer for the state of New York. And one of the boxes I have to check off says, in the past 2 years, took 24 CLE credits. Now, I can lie about that. I can check that box off and say I did it, and if no complaint is ever filed against me, it's unlikely anyone will ever find out. But if a complaint is filed against me, and the state bar says, in addition to the complaint, show us your CLE records, you know what happens to me. I can be suspended, disbarred, etc. So tell me, how did that happen? that the box was checked off when in fact it didn't happen at all?
I can assure you no one here is lying. And
Right, that's why I wanted to start off with it. We're not lying. And again, as I think I had mentioned this before, our LIM system was in place, and then we went forward, and the LIM system had bugs. And unfortunately, and it was probably a miscommunication on my part, we were supposed to do a paper chain of custody from when the evidence got because the LIMS wasn't available. Marv, if you came to my laboratory now and go to these cases, at some point the electronic case chain of custody was back up and running and there were transfers. I did show that to the technical assessor, but however, because the paper chain of custody was checked off and wasn't in the case file, I don't think it was enough for the auditor to say, hey, look, we had some LIMS issues. I don't have any excuse for not having the paper chain in the case file. But we do have an electronic chain of custody which had some problems in the beginning, which was tracked after the case began. We do have it now. They checked yes because their assumption was that the chain of custody was there, and the latent print section prior to this audit did not feel it necessary to add the electronic chain of custody to the file. Since the audit, we are now including a copy of our chain of custody with every file. So there is a chain of custody. It does exist. It's just not part of the file right now, and there were some bugs with it, but we do have transfers within the LIMS on those mock cases. But again, there is no excuse for not having the paper one when the LIMS was out of service for that week or two.
I have no further questions, Mr. Chairman. I'll await the general discussion on Nassau County.
Do we have any other questions for Nassau? Yes.
Yes, I have one question just to clarify this further. It seems to me that the problem here was the technical review, not so much that the chain of custody was not filled out. And yet the corrective action says that you're going to focus on making sure the chain of custody is filled out. How are you going to deal with proper technical review?
Mark, do you want to discuss that?
Part of the remediation for that finding is to look at the technical review as a whole with a focus on the chain of custody, but all those aspects will be evaluated. Every checkpoint on that list will be evaluated.
Because, that's my concern about technical review of other items.
Yeah, Dr. Stodge, yes, it does give the look that no technical review was done in those cases, but it's not the case. I mean, I will sit here and I'll swear to you that it's not the case. We just need to do a better job of documenting it. And again, as we've set certain things in place now, especially with the remediation process for our not our technical leader, for our QA person to basically be the admin close of these cases so that Mark can now go through all these cases to make sure that everything is in place, that the examiners understand the LIMS and how the LIMS functions. Because the technical review aspect is also part of the LIMS.
Okay, so you're going to include that in your corrective action?
Correct.
That's right.
Okay, thank you.
Michael?
Peter?
Sorry?
Thank you. Andy, Karen, anybody, I guess. On your reports, as opposed to the case file.
I'm sorry, could you repeat that?
Sure. In your written report on a case, involving latent print examination, if the examiner, when they look at the latent, sees something, which later on they want to conclude is an artifact, even if it's clearly discordant data, could be an artifact, it could also be the basis of an exclusion, but given the experience and expertise of the examiner, he or she concludes it's merely an artifact. Will that fact that there was discordant data be reflected in the actual report?
Not in the report, but in the case notes.
Right, and in the report, we are clear that it's upon discovery that the report is not the only part of the case file, that there's additional information.
I understand that, but there are certain things that are actually, more important than other things, and they belong in a report. What was the reason that you folks decided that when you do see discordant data, which would obviously be very important to a judge, a fact finder, or an opposing attorney, that your assessment of that discordant data being an artifact as opposed to the basis of an exclusion doesn't belong in the report.
Jen, I'm going
like Pat said, we state in there that, again, the information in the case file is available for review, and that's
I'm not asking that question. I'm asking why. Look, how many pages is the report?
It depends on the
If you're looking at a
material
single
that's
print,
being
what's the
analyzed.
standard? What's the
It could
standard?
be 2 to 3 pages.
Fine. All I'm asking is why is there not a paragraph in there where you inform the reader that there was discordant data, but it was the opinion or conclusion of the examiner that all of that data could be explained as artifactual in nature?
We do mention the quality of the print, or if the exemplar print isn't sufficient for comparison. But that's it.
Why don't you include explicitly, if you do see discordant data, why is that not in the report?
At this time, we don't.
I didn't ask
why.
I didn't
That's
ask
his
why.
whether it is. I asked
Why.
Why did you decide to omit that from the report? That's my question.
Well, again, I'll answer it with, it's not in the report because it is accessible in the notes. I realize you feel like I'm not answering your question, but...
You're not. Pat, can you answer the question as to why you decided that that category of information does not belong in the report?
Well, the reasoning is because, I guess there could be arguments about other requirements in the report that are not there. We felt that it was sufficient enough, and we've never denied a discovery that part of the case notes, and I'm not familiar with any trial that I've gone forward where we haven't handed out discovery. Now, it's just something that we decided that we're not going to talk. Again, this is above my head in terms of artifactual and so forth, and why it's not in there as an explanation. I know it does, Jen, in terms of if the sample does have artifacts and that's why it's not being used, then how would we express that in a report?
Well, it may be deemed completely insufficient for comparison purposes.
But it may not be. It may be deemed sufficient.
You're right.
And still a match. My question is this. One thing is very, very clear, which is that the purpose of a report, the report has one purpose, the case file has another purpose. The case file allows opposing counsel to retain an expert who can review the case file and make an independent assessment. Okay, that's the purpose of the case file. A report, though, is written for lay people. A judge, a prosecutor, a defense attorney, and bells and whistles go off, and conclusions and actions are taken on the basis of what somebody who is not scientifically literate reads in that report. And so it would seem to me, based on my experience in criminal defense work and in civil rights litigation over the last 30 years, that you would certainly want to include for the layperson in the report, so bells and whistles would go off, the fact that discordant data was observed, but it can be explained away as simply an artifact. And when I say this, I mention that if this report was being written for a federal court, as opposed to a court in New York State, it would be an unacceptable report unless it included a statement trying to, number one, identify the discordant data, and two, explain the basis for why it's merely artifactual in nature. So that kind of report that doesn't have that would be inadmissible and unacceptable in a federal court of law. And the federal courts have that standard, have that bar up here, because they believe it's essential that lay people have a certain understanding of what happened. And it also, to follow up on something that Barry said before, what you need in a report for any federal case is not just the conclusions of the analyst, but all the bases for those conclusions. Okay, and if you don't list the bases for the conclusions, it would be an unacceptable, inadmissible report, and the examiner would be prohibited from testifying to her conclusions at the trial. And I just think, as a matter of whether it's best practices or minimum standards that we want to have here in New York, it's very troubling when something as glaring as discordant data, which can make or break a fingerprint conclusion, is not included in the report itself.
Pete, in terms of having that information for the match itself, the issue that Barry brought up, I think Jen explained why we feel how we meet that criteria in terms of if it's not the annotation, then it's going to be clear enough in the notes. But and I'm not trying to be confrontational, but could you send me the verbiage on that? Why that wouldn't be acceptable in a federal court? If it's something that we can work with, given that information, then I'm not opposed to it. It's just something that I really would like to also bring forward to the TWIGs if we even have TWIG meetings, since the majority of labs are unaccredited. So I'm not opposed to making that amendment in the report. It just would help me to see, the rationale of why it wouldn't be acceptable. I mean, I think what we're saying is it is part of the notes, but your opinion is it's not accepted federally because it has to be in the report itself and clearly stated. And I'm not arguing. It would help me out to basically base how we would, work this into our workflow or place this into our workflow.
Do we have any other questions for Nassau? I want to try and move at least this issue on because Dr. Wiley has to leave by 2:45, and if we can, I'd like to wrap up at least this part of the agenda before then. Right, if there are no other questions, do we have any discussion or any proposed action on this issue? Yes.
I'd like to make a motion that we affirm our encouragement for Nassau County to develop accreditation of this discipline and continue their provisional accreditation through June. However, we ask that they not proceed with real casework until they have completed 6 additional mock cases and ASPAD Lab has determined that the deficiencies have been corrected.
Do I understand correctly, Mr. Chairman, that the current provisional accreditation we previously was voted by the Commission is currently, right now, through June?
I believe it's through June 7th.
So it's verbiage and surplusage in this motion to talk about continuing something through June. And therefore, I think the motion's out of order, or at least that section of it is. Let's try to be a little bit more circumspect. I have no problem with the portion of the motion that talks about the other areas, such as mock cases versus real cases, but I don't think we need a second vote to affirm that something should continue through June. That currently is through June.
There is only one problem.
It's June 7th is the date.
If their accreditation ends June 7th, the next commission meeting is June 15th. So perhaps continuing it till June 15th is not unreasonable.
Perfectly acceptable.
I have a question. I don't understand something. Maybe Ann or someone else can answer the question. Lapse in memory. Under provisional accreditation, could they, prior to June, handle real cases and issue a report in a real case?
That was always the policy. That is why we had provisional accreditation. It allowed people to do casework, and their current provisional accreditation allows them to do real casework. So I think that in order to do we would have to provide Nassau with a hearing to take away, to revoke, suspend, or otherwise limit pursuant to 9 NYCR 6190.6. They're entitled to a hearing if we want to limit that.
Except they've come to us and asked. They've said it is their intention, and they've asked. And I'm making a motion that says that the commission would like to say no.
Can I add that the remediation plan, part of what ASCLD Lab was expecting was real cases, so that would change that accepted remediation plan. And on top of that, I would just like to say that the mock cases are somewhat problematic because, number one, we need other agencies to get them to us. They're not in the normal course of business, the way things normally come in as far as chain of custody, and they're not always the best test of your lab system for those reasons. It was our intent to remediate all these things in the same way, and the first cases that we produced would be sent, and that's part of the caveat from ASCLD Lab, would be sent to the FBI technical assessor for him to review.
Let me just...
Karen, what's the time frame on that we've been given?
Pat, before you go on...
We held off on that to this meeting.
Pat, before you go on, I'm struggling with the motion here in trying to understand what legal authority we have. We've granted the lab provisional accreditation to do latent fingerprint work through June 7th. As I'm reading the rules that govern our conduct under 9 New York Code of Rules and Regulation, I don't see where we have the authority to take that away absent granting them a hearing, giving them notice, conducting a hearing, and making findings. So if we're not going to do that, the only thing I see we could do consistent with that motion, is ask Nassau, we wanted to ask them to voluntarily do something. But we've granted them provisional accreditation, and if we're going to take that away, it's my view that our rules require us to give them notice and to hold a hearing.
And I'm
just a question, Michael.
Give all the hearing.
Yes, Peter?
I'm sorry, I thought Ann was talking. My question is just, again, I don't know the rules. I'll defer to you on the rules. But number one, they could consent, if it's the sense of this body, that they should not be flying solo on actual casework, that instead that it would be the sense of this body to do as Ann suggested, namely that until such time as there is either that kind of review by ASCOT Lab or further review by this commission, whatever, by somebody, that they can only do casework if it's being done in parallel by another accredited laboratory that reaches the results on its own. They can consent to that, right?
I do have a, for that plan, I can set that up. I just don't want to name that laboratory until I speak to them first. So there is a possibility of us doing the 10 cases and sending them to another lab to be verified, but at the same time, we still have to send those to ASCLAD Lab because ASCLAD is looking for true casework. I don't have an issue with anybody verifying our work. I think our product is suitable, more than suitable, and I think that's a great idea as long as one of the local labs will extend a hand out to us and verify our work.
To answer your question, Peter, I don't see anything wrong with us making a recommendation if they're willing to follow it. I think we have Dr. Corrado is.
Yeah. I would just like to say I think it's great that Pat's willing to do that, but I think my thought on the issue is the mock cases that they did, there was no question about the results, if they got the correct results. So at the point of sending
they weren't technical
to another accredited lab is to make sure they got the right results. I don't really think that's the issue. The issue ASCLAD has is everything documented the way ASCLAD Lab believes it should be documented, and sending that to another lab isn't really going to answer that question. I think the idea is if they do these cases and they send them to the ASCLAD Lab auditors, they will look at that and say, they'll look at both. Are they doing it, are they following the procedures and doing it sufficiently? Also, are they getting the right results? I think in my mind, that's a better test. And maybe the issue is we want to set a limit on the number of cases such that I don't know how many cases they can do in the amount of time before ASCLAD comes out, but we could say they can do mock casework up to a certain number of cases or something. So if someone's concerned that they're going to continue to go on and do something that won't be caught. But I don't think the issue is in their ability to identify latent prints. I think the issue was in their documentation. I don't think sending it to another lab will address that. I guess I have one other thing, but I don't remember exactly what I was...
Did you mean mock casework or actual casework?
I think actual casework. I think their point is the mock cases are there's problematic with the mock cases. So I think doing the actual cases and then sending those cases to the ASCLAD Lab inspector to review to determine if those cases have the sufficient documentation is really all that needs to be done. And again, I don't think the issue is that they weren't getting the right results, so I don't think sending them to another lab is going to answer that question. Or I don't think it's necessary to answer that question, I should say.
Kathy, can I say one quick thing? Just in terms of, obviously there's a concern about the number of cases that we'll be putting out before the assessment team comes back. To let you know, the intent of this new department is not to handle the processing, is not to handle the day in and day out comparisons. We're here strictly for the verifications until we get more personnel. So right now, Westchester is handling our verifications. we'd rather do the verifications ourselves. So to let you know, there are only 4 verifications that are waiting now for us to get going. So we're not getting 1,000 cases. We're only getting those cases that need to be verified. We're concerned here on our end because we're hoping we can get enough casework back to ASCLD before, for the date that they even need it. So, we're concerned. We don't see 10 prints. We don't see 10 prints on a normal basis. We don't have body identifications on a regular basis. It's the verifications that we're hoping to get approval from the commission to be able to take from the police department to be the verifier. And I agree with Kathy. Again, I don't think we have technical issues. I think we just had a bad start with our documentation and our administrative, portion of the laboratory. And I believe we're set and we are ready to get going with casework.
One thing that's, I think, actually, there's a misconception here when you say our results are fine, we're just having a problem with some of these technical administrative matters. All those technical administrative matters which have been developed are developed by accrediting bodies because they consider them part of the quality assurance process. And you can't separate these things as cleanly as some of you are trying to separate them. I think that's really a mistake. In that regard, I'd like to know now, when you're sending out things for verification, are you sending out all the cases, whether they're inclusions, exclusions, or inconclusive, or only a subset of cases?
A subset of cases, those which have been identified and are required for court. So the district attorney feels comfortable at this point now getting an identification from NCPD, sending it over to Sergeant Dowd's lab. They've been very good with handling our verifications. We would like to take that over. So it's a subset of cases.
What I'm talking is something very, very different.
Okay.
When I heard Ann talk about a parallel review by a different laboratory, I thought what she had in mind, or at least what I have in mind, is that a separate laboratory independently look at these cases, win, lose, or draw, whether they're inclusions, exclusions, or inconclusive, and independently reach a conclusion. If you only send out to the other laboratory those cases where you declared a match, then the laboratory already has that information that these are cases where somebody else has already declared a match. For this thing to work well, particularly given some of these quality assurance failures, and that's what they were, you may call them administrative, but I think they are QC failures. I think it's essential that a parallel laboratory just get the cases for this abbreviated period of time.
I definitely don't have a problem. The only problem, Peter, is that the only cases that we're going to see are identified cases. Jen, am I on the money here, or am I? I know we do have more people on the way and people with experience, but at this point now, the police department knows that they're handling all the local issues. The only thing we're doing is preventing cases from going to Westchester because we're inundating Westchester.
That's correct.
Dr. Wiley?
You know your cases that the police department has already declared a match?
Wait, Peter, Dr. Wiley had the floor here.
I will withdraw my previous motion, but I want to comment that we're now, and I apologize that this discussion has put fingerprinting on trial, to some extent, and the efforts of this lab to get up and running on trial to some extent. But the comments you just made, Dr. Buffalino, are very disturbing because they're bringing us right back to where we were when the lab closed. And the expectation that the Nassau County Police Department would go back to doing latent print development. And the question raised by this commission that said they can't do that. They're the ones who got you in trouble in the first place. And what you've just said suggests that that's where the print analysis is being done, and that when the police department gets a match, they're sending their match prints to Westchester County, an accredited lab, who's doing the verifications, rather than sending them to you because you don't have your formal ASCLD lab accreditation. And I'm back to saying we haven't solved any of the original problem. Notwithstanding your good faith efforts, But we're right back to a real morass in Nassau County about how prints are being done and where they're being done and disclosure of how the system's working or not working. And unfortunately, I have to leave, and I won't be here to hear the rest of the discussion.
Okay, so I won't. So then I'm not going to respond then. Are you walking out now? Because unfortunately, I don't have control over that process. To have this laboratory be responsible for processing comparisons and verifications on every case is just not a possibility at this point. We've started off with 2 individuals. We are hoping to get full ASCLD accreditation, and unfortunately, the only way to do this is to take on these comparisons. Yes, it's not the way we want it, and I don't even have to ask Jen whether she is comfortable with process work coming to her. But unfortunately, these are the circumstances that we're under right now.
All right, the motion has been withdrawn. Is there any other discussion on this item before we move on?
Yes, with reference to the mock cases.
Yes.
Hang on, Dr. Jenny has the floor.
Last meeting, NISPLA recommended and the commission adopted use of mock cases. The use of mock cases is a new option under ASCLD Lab. That is successful, a ASCLD Lab will grant a 1-year accreditation. What I'm hearing in this discussion, Kathy seems to back that up, that in fact mock cases are not a valid challenge to laboratories. Is NISPLA going to rescind its recommendation?
I'm not going to say that that's true. I think what Pat was saying, the way they handled these mock cases, they weren't, because they're not putting them into their limb system, it wasn't able to test those things.
But that's remedy.
Right. So I don't know. I think they're probably pretty good. They may not be perfect. But in typical situation, this is a different situation because you have a lab that's trying to bring on new disciplines as opposed to just adding something, adding a discipline. This is kind of a new thing for them. But I don't know. I think this was a good test case, and maybe we'll see if it comes up again how the mock cases work. I don't know, other than going back to the drawing board, which is provisional accreditation, which is the same issue we're discussing now. I mean, I don't know which one is the better way to go.
Provisional accreditation, which is no longer an option, so that's what we faced in the last meeting. But I'd like to get back to provisional accreditation. Is provisional upon a laboratory meeting accreditation program requirements? The laboratory has had inspections found not to meet outside lab requirements. Does statute speak to provisional accreditation with regard to need of adhering to?
It doesn't speak to it specifically. So technically there may not be any process for that, but the way the regs are written, it appears that they would need to be afforded a hearing because the reasons for taking away accreditation, it doesn't specifically distinguish between full accreditation and provisional. So the way that the regs are written gives various reasons like guilty of misrepresentation, unacceptable error rate. So I don't know, is this 5% error rate an unacceptable error rate because there's 400 standards? So there's not meeting 10 of them, an unacceptable error. I guess those are the issues that need to be addressed.
I guess what's confusing to me is that... Go
Yeah.
ahead.
I just have a question again, not a position. I'm still not clear on something. If you start doing cases, are they going to be only actual cases where members of the Nassau County Police Department have made a threshold determination that there's a match?
That's correct.
I'm sorry. Then again, I have a question for the chairman or for somebody else who has a better memory than I do. I thought a while ago it was determined that the Nassau County Police Department could not do latent print work.
I'm sorry, Nassau County, you mean PD or ME?
Nassau County PD couldn't do latent.
Nassau County PD has been doing latent prints since, the lab closed down.
Peter, I don't know that we have any authority over Nassau PD. We had authority and we made certain findings with regard to a crime laboratory that was run by Nassau Police Department. Yeah, but that's a bigger question. It hasn't really been brought up here, is if we take action, I don't know that we can without a hearing, but if we took action to prevent this laboratory from doing latent prints, the question is who does those latent prints? And then there's nothing to stop the police department from doing them without the help of a laboratory. And we don't have the authority to tell the laboratory not to do it.
Well, but here's the problem, though. The problem is that in assessing the rigor of the work that's being conducted now by this new Latent unit in the medical examiner's office, is that they know that the only cases they're getting are cases in which the police department Latent examiners have declared a match. That's correct, right?
We are getting their cases with identifications, yes.
Only identifications. And so, in a sense, there's no kind of even ability to get to the most fundamental question as to the competency or the rigor, if you will, of these examiners, because they already know, okay, a priority, that a match has been declared for these cases. So it raises all those same cognitive issues.
Actually, in the few cases we did receive, there were more than
You received
one.
what?
Actually, in the few cases that we did look at for verifications, there were additional prints that weren't IDs. So, I mean, there were other
But
prints.
did you know that they had determined that the other prints were not IDs and only print number 1 and 3 were
The only way we would know they weren't IDs is that they didn't declare them IDs in a report, because that's the extent of the documentation that we have.
So you get a report that tells you which one they declared an ID,
That's
which
right.
ones they didn't. Okay, so that's the same problem. What I'm saying is you still are missing that kind of fundamental assessment here, and given all the other QA problems that we've seen, which are not trivial and not simply administrative, because they go to the heart of any kind of quality assurance program, that even if you say we cannot modify their provisional accreditation, in light of the answers, in light of the information that we now have, I would move that we do withdraw that provisional accreditation to do real cases until such time that this entity sees proof that all those other problems are no longer a problem, and we actually see the cases worked up ourselves, and we see the reports that are written, given the whole history of the situation. And if, as you pointed out, Mike, all we can do is then give them notification and set up a hearing, then my motion seeks that.
All right, so you're making a motion, if I understand it, Peter, that we give them notice and hold a hearing pursuant to 9 NYCRR 6190 sub 6, I guess it would be, that we give them notice and hold a hearing for the purposes of revoking or modifying their accreditation.
Well, only I'll defer to you again on all those sections and subsections. But given, based on what you told us the rules are, yes.
All right, is there a second to that motion?
I think Barry seconded.
Yes.
All right, do we have any discussion on that motion?
But I guess I'm a little confused. I understand where you're going with this, but I think it sends the wrong message, because I think what Nassau County is going to hear is this lab isn't up to doing these cases. We should just send them all back to the PD, and they're going to take their furniture out again. I mean, I think there should be a better way around this than revoking their accreditation. When you revoke accreditation, it sounds like I think something maybe worse than what we're looking at here. I think if you want to delay and ask them to not work on casework until they do more mock cases, maybe that are more representative of actual cases, and have that reviewed, that's the way to go. I mean, you can ask them to voluntarily not do more casework and try to meet in another way, but I'm concerned about revoking an accreditation and the message that sends regarding the laboratory and back to Nassau County.
Dr. Buffalino, before we vote on the motion that's on the floor, would you be willing to accept a recommendation from the commission that you not engage in any actual casework pending, further approval from the commission?
I can't answer that question until I speak to ASCLD Lab if they're going to accept additional mock cases for the review process. I believe Bill Smith was clear in his memo that he's awaiting for actual cases comparable to these NAs.
All right, I guess we have a motion on the floor. It's been seconded.
One other comment.
Any further? I'm sorry, Peter.
Yeah, Michael, I just have another comment in response to Kathy, which is I appreciate your concern about sending them a message and not sending the wrong message. But I think what you're advocating is a lesser of evils approach, which I think is actually in some ways more dangerous. Because if something does not meet what we consider to be in compliance with the scientific method, then we have a duty to act. It's not for us to consider that if something is completely inadequate, that a fallback position might be something worse. I mean, obviously, ultimately, and I think Michael was alluding to this before, we're going to need legislation or rulemaking to expand the jurisdiction of this body over to people who are doing latent print analysis in police departments and not just crime laboratories. But if we don't think they're complying with the scientific method, then we have a duty to not allow them to go forward with actual casework.
Is it safe to assume that the commission has a concern with ASCLD reviewing our remediations and our review of our SOPs with revisions that isn't sufficient enough to move forward? Now I've got to make a phone call to ASCLD to see if mock cases are going to be acceptable at this point.
Before you do that, Pat, could I just ask
And I understand it's Nassau County. I understand 10 findings look bad, but for a laboratory that has gone for ISO accreditation, who has never had a latent laboratory, you know, I believe it's less than 5% of the ISO criteria. I'm not quite sure how am I supposed to put this to the ASCLD. Is it that we are looking to do more mock cases, or are we looking to get ASCLD in here quicker?
Could I just ask a quick question, Pat? Are you scheduled to be either accredited or not accredited by our June 15th meeting? With actual
the average time is about 9 months. We can get them back in here. So I don't think by June. Now I can put everything on a rush. We can process these cases, send them to the FBI technical leader, and basically see if I can get Bill Smith back here before June 7th. They've been very accommodating to us, but I just want to make sure that we're all on board with one plan before I start making any phone calls.
I think that would be. I understand Peter's concern, but I think that would be a more acceptable procedure to try to speed the process up. Because the alternative is they're just going to send the work back to Nassau PD and the hell with us.
All right, we have a motion.
One additional point of clarification, please, Pat. Where in the letter does it state that the additional casework must be real casework? What I'm reading is that the lab will need to provide casework documentation on at least 3 additional cases per examiner. Is that not referring to mock?
Yeah, Karen, go ahead.
Can I speak to that? So, as you know, ASCLD Lab is a process. We had 30 days to respond once we got the final assessment. We responded very quickly, the February 29th letter. And then after that, ASCLD Lab reviews what we've sent them, and then they send us a dialogue back, which they sent a dialogue back saying that they reviewed the plan and they've accepted it with certain caveats. And that was in an email form. And in the normal course of business, we would write up all these nonconformances, we would give them our protocols, we would demonstrate our casework, and they would see whether or not we are in compliance or not. So that this particular plan, what they're saying was that the February 29th plan, most of it was acceptable, but they wanted to see more from us. And specifically what they wanted to see was they wanted to see at least 5 cases per analyst of regular casework from us.
And again, that brings me back to, and again, I really don't want to speak for ASCLD. I don't think mock cases are a good way to go. It was something that we discussed at 9 o'clock. I thought it was a good idea myself. I'm thinking differently after this inspection because I'm going through the inspection report, and about 50% of it is non-applicable. So now the other catch would be now I've got to create or find these mock cases that cover every scenario, which could take, I can't tell you how long that would take.
All right, we've got a motion on the table, and the motion was seconded. Yes, Peter.
I'm sorry, just as a process, why couldn't your laboratory benefit from the generosity of strangers or friends in New York and take a second look at cases that they've already processed, as opposed to mock cases. So you're not actually making the decisions that go into court, but they're real cases. You don't know whether they were inconclusive exclusions or inclusions by those other laboratories.
That was our competency test. So we did that for their
They've had 2
competency.
rounds
And
of
then
competency
again,
tests.
we had the second competency test, and we had no issues this time around, and they've been cleared for casework.
You have these other issues in terms of the way the quality assurance program is working. So I'm
Right,
basically saying,
and just to speak to that, we in no way are trivializing any of these things. If it seems that we say that they're administrative, it is because the current program is built on our prior accreditation and our certification by ASCLD Lab. And most of those policies and procedures were migrated to the latent discipline. So we just had people in from ASCLD Lab within the last few months. They did not find all these deficiencies in chain of custody in the DNA section. We function on the same premise. We have the same protocols for chain of custody. So when we're saying administrative, I guess that's why we're saying administrative, and you may feel that it's trivializing them. I don't trivialize this at all. We know how this looks.
I don't want to be rude, but I'm going to interrupt. Wait a minute. I don't want to be rude, but I am going to interrupt because I think we all understand. I think we've been through this 2 or 3 times now. We have a motion on the floor. The motion's been seconded. We've had discussion, so I think it's time that we should vote on Peter's motion. Everybody in favor of the motion? All right, so there's 3 in New York. There's 4 in New York.
there's
1 here, Dr.
Four
Jenny.
in New York.
All right, so that's 5 in favor. All opposed? All right, there's 4 opposed, and is anyone abstaining? All right, there's 5 opposed. I'm sorry. So it's 5 and 5, so the motion does not pass. I would make a statement, and I don't think it needs to be in the form of a motion to be voted on, but I think it would be a very good idea for the laboratory to do everything they can to rush that accreditation process and to get some feedback for the commission by the next meeting, because the provisional accreditation expires on June 7th, and from what I'm hearing from the commission members, it doesn't sound like there'd be a lot of support for taking action, absent some strong showing from ASCLD that these issues have been addressed. So I think that takes care of this issue. I think our next issue is on to new business, and our first agenda item with regard to new business is the New York Crime Laboratory Advisory Committee's reanalysis program. Dr. Corrado, if I can have you just give us a brief outline on that.
Sure. If any people from the commission remember, back in 2009, the laboratories voluntarily agreed to institute a casework reanalysis program. This basically involves the reanalysis of a case originally worked by one analyst is reanalyzed by a second analyst. It's basically a blind test of the first examiner that they don't know which cases are going to be chosen for reanalysis. It also looks at what the second analyst did as well. We believe it's a good system in that it allows us to look at the entire case, including evidence packaging, sealing, labeling, sampling, note-taking, the technical review process, as well as the reporting. So when we instituted this reanalysis program in the state, we agreed that we would come back and report back to the commission how it was working. So basically, the summary is fairly self-explanatory. In 2010, there were 439 cases reanalyzed, and in 2011, there were 482 cases reanalyzed. And this reanalysis program has allowed labs to identify quality improvement measures, as well as in a few cases, some corrective actions came out of that program. So we believe that it's a good system in place, and we're just basically offering this as an update.
One question I had when I looked at this is what provisions are made in terms of chain of custody and preservation of evidence? Is there the possibility that any of these cases you're looking at are going to be, the evidence is going to be needed for retrial or some other purpose in the future?
It's a good question. When NICLAC got together to discuss how we were going to implement this program, that was one of the things we talked about. And so the cases are actually chosen by a supervisor or a quality assurance manager, or someone, outside of the person doing the test. And we actually look at that. We look at the cases to make sure that they're cases that have sufficient sample, that if we do have to consume additional sample, that it's okay. We also make sure, it's not something that is a type of thing where if the case is going to trial the next week, we're not going to reassign it for reanalysis then. We kind of look at that kind of thing to make sure that the cases that are being chosen are appropriate, so it's hopefully not going to affect the outcome down the road.
Any other questions or discussion on this item?
Yes.
Yes.
Yeah. Who chooses the cases for the other lab to be reanalyzed? Is it I take it it's the administrator of the lab whose cases are going to be reviewed?
The cases are actually reanalyzed. The cases are actually reanalyzed in the same lab, so it's the administration within the lab that chooses the cases to be reanalyzed.
Oh, you mean that the reanalysis program is not that another lab analyzes Lab A's case is not reanalyzed by Lab B?
Correct.
No, the case is reanalyzed within the same lab using the same policies and procedures.
Different analysts.
A different analyst within the lab. So how is that anything? How can you say here that this acts as a blind test? How is that a blind test?
It's a blind test.
It seems to me that this is nothing more than peer review within a laboratory, right?
It's different than peer review because it is blind to the first examiner in that the cases are chosen at random. So you can't say that it's different from a proficiency test that's declared up front where the person knows it's a proficiency test. And this is just an average everyday case that they would complete the way they would in a regular case. And then the second analyst comes in and it's different than just a peer review because they're actually reanalyzing. So for instance, in a serology case, if there's a sexual assault kit or clothing or something like that, they will take that evidence out and they'll relook at the evidence, relook at the slides. Where did the first analyst say there were no sperm, and now when the second analyst looks at it, do they find sperm? So it's basically reanalyzing the case, looking at all of the evidence again. And then it also allows, so it's checking those results in that sense. But what we found, at least in my laboratory, one of the things that was interesting is when you look at a case independently, you're just looking where the policies follow. But when you have two different examiners' notes in front of you, you might see that one examiner might take more extensive notes than another or something like that. So it actually allowed us to see things that we might want to add to a policy to make things more consistent and more stringent. So it's an interesting thing to see the way two different people, approach a case and are they actually doing the same kinds of things.
I think nomenclature is important, and history is important in this area. And Mike, it might be of some interest to you. This goes all the way back to the DNA Identification Act of 1992, 94,
I think
where
it's
the United States Congress, 94, the United States Congress set up a commission because the Congress had indicated that the best quality assurance would be to have what we would call external double-blind proficiency tests on samples that replicate casework. A commission was set up. The commission said, yes, those are possible, but they're somewhat expensive. In fact, Paul Schechtman, when he was the commissioner, did a blind test, as I recall, on some sexual assault upstate. And then another alternative was proposed as a substitute for external blind proficiency tests on samples that replicate casework. And that suggestion was, quote-unquote, reanalysis by laboratories. In the forms that are passed out here by ASCLAD and where most of our laboratories, check off that they don't do external blind proficiency tests, and some say they do reanalysis and some don't. The term reanalysis, as I understood it, was supposed to be that Lab B was going to look at the cases of Lab A that were closed cases from the beginning, right? and analyze it as a new case. And that was the check as opposed to external blind proficiency testing. I know that's not what you did. I understand what you did. I'm not even saying that what you did is not a good procedure for an internal review by a laboratory. But that's not my understanding of what reanalysis was supposed to be under these guidelines as a substitute for external blind proficiency testing on samples that replicate casework.
My understanding, I would disagree with that. My understanding is in the legacy program, the option was, as you said, external blind proficiency testing or a laboratory reanalysis program. And my understanding is the internal reanalysis is what they were referring to there. I also think that was part of the legacy program. I don't believe that's still a requirement in the ISO program.
All right, thank you. Is there any other discussion on this issue? Yes, Marvin.
Yes. First, would it be possible to get this report on the stationery of the organization who gave it to us? I saw this report when I went over the materials, and I had no idea where it came from. And it's not signed by anybody, so who is this report from?
I apologize. That would be an oversight on my part. The stationery typically was used for letters, and I didn't actually consider this a letter, but I can certainly reprint it on the NICLAC letterhead. But I apologize. This was an update. I should have said update from NICLAC. That was my oversight.
Okay, I would respectfully request that it be resubmitted and made part of the official binder, and that it be circulated on the website on your stationery and signed by somebody at NICLAC, so that this purports to be a report from NICLAC. The second question I have is this. Where did these statistics come from? How were they gathered? That, for example, there's 439 cases in 17 labs, 482 in 18 labs. How was that gathered? Who gathered that information? Where is that research? Who has it?
That was information gathered by NICLAC. I asked the labs to send me their data, and I compiled it. And that's the summary. This is the summary that you see here.
And so it was basically reports from different labs. Is that correct?
Yes, each lab reported what they had done.
And you were able to determine from what you received that of the participating labs, 50% of the disciplines in the labs were performing reanalysis? At least 50% of all disciplines? You were able to figure that out from what you learned from the labs?
One of the questions we had asked the labs was, are you performing the reanalysis in at least 50% of your disciplines? And I believe all of the labs answered yes to that. That was one of the requirements that ASCOD Lab had in their legacy program, was that in order to receive a yes for that, you had to have been doing it in at least 50% of your disciplines.
Where is the research currently? Where is it in possession of NICLAC?
I don't know what you mean by research. This is
in other words,
summary.
the backup for the claims that are made in this report, are they in your possession?
I have a chart of the number of cases that were worked by the laboratories, yes.
Okay, thank you.
All right, any other discussion on this item? All right, our next item is a...
I had my hand raised, Mike.
I'm sorry, I can't see you there. You're in the shadows.
I'm sorry about that.
No, please, go ahead.
I just want to make it clear. It's Barry. I was on that commission in 1994, that was chaired by Joe Peterson and Bob Ganslin. And we've asked this question every time that we get reports in here about what reanalysis is. And I've got to tell you that if reanalysis is supposed to be a substitute for external blind proficiency testing, and you're not even using a different laboratory to reanalyze another laboratory's work, then it really is not serving as any kind of a substitute for it. And regardless of, Dr. Corrado, I've read your comments about the OIG investigation and other things here. This, to me, is a very good example of how people within laboratories in their own disciplines really can't be trusted to analyze themselves if you're calling this reanalysis. This is just internal review by labs. It's not the same laboratory. It's not a real external check. That's not my understanding of what reanalysis was supposed to accomplish as a more efficient and cheap substitute for external blind proficiency testing. And so if you're wondering why people that have been in this field for 20 years looking at this stuff are skeptical that the laboratories can police themselves without an independent commission and people that are outside of the laboratories, this is why. Because this report, to be frank with you, doesn't tell me anything about what the results were, what was identified as improvements or things that need to be improved, and it certainly is not having one lab check on another. And if we need any other examples, we've already had this discussion where I agree with Pat Buffalino and the people from Nassau that if you went out and you started looking at fingerprint analysis from all these different laboratories, you would get inter-analyst variation on something very important that just happened to Bill Fitzpatrick on his case, false negatives. And all the data is showing that. And we've got to do a lot more to move forward as a commission. The OIG recommendations we're talking about more quality assurance from this commission. And my suggestion
I don't think we're talking about those yet, are we? I'm not sure we've gotten to those recommendations yet. I thought they were a little later in the agenda.
They are, and
Thank you.
And Mike, I just made this comment to note that because I know that discussion is coming and to flag it for you.
Okay, thank you. I appreciate your position on that. Next item on the agenda is a letter from Asclad Lab. My understanding that there was an issue at our last meeting regarding why crime scene is not required to be accredited, and there is a letter in your material from Asclad Lab explaining their position on that issue. Next item on the agenda relates to the Dcjs annual reporting. Kathy, do you have any comments on that?
Yes, I'll just want to present a few of the issues before we discuss the annual reporting. We receive that, the Commission receives that annual reporting information each year. You're looking at primarily the information that we receive from the laboratories from 2011. On occasion, there is maybe a closure letter from 2012 that we put in, so we don't have to carry the issue over again to the 2012 reporting. The DNA subcommittee met on last Friday, and they did review the annual reporting for the DNA laboratories, just for your information. And also, it's noted in the area of additional documentation on those charts that if an issue was discussed at either the DNA subcommittee or the commission meeting, those dates of those meetings are noted there. And another point we want to make with the closure of the Nassau PD laboratory, some of the issues ended up that were still ongoing with the PD labs, such as the blood alcohol issues were transferred to the ME Tox lab in Nassau County. But just so you know that issue did not originate with the Tox lab. That is a PD issue. And therefore, also one other point, in some of these issues that you might see in what we highlight is proficiency tests and casework problems. And some of these issues are old issues because if there's a current closure on that issue, you are seeing that issue again. So for example, NYPD, you're seeing 2009 and 2010 issues. We have finally closed it out, and you're seeing it again, but it is not a new issue.
Any questions or any discussion with regard to the annual reporting?
I have a question, Kevin.
Yes.
I don't know, is Dr. Lehrer in Albany?
I'm sorry, we couldn't hear that.
Oh, no, he's not.
I was wondering no, okay, he's not here either. I have a question about the Suffolk County Office of the Chief Medical Examiner Toxicology Laboratory. It seems that what they're submitting compared to all the other toxicology labs is very minimal. And I don't know if that got omitted or it was never submitted, but there should have been definitely their mid-cycle data should have been sent sometime during the 2011.
It's possible we might have missed that. I don't know. We can get back to you on that.
Okay.
Good eyes.
Any other questions or discussion with regard to the DCJS annual reporting? Yes, Doctor.
Only to acknowledge that it's a tremendous amount of work in compiling these annual reports. I've said that to say it. They're very insightful. Didn't have sufficient time, however, to review all these materials before the meeting. Is your office aware of the situation that we should discuss in the way of patterns and proficiency testing? That raise concern?
No, I can't highlight any specific issue. A lot of the current issues you received, this was a 30-day reporting of some of the lab disclosures. And this is more to give a snapshot view of the whole laboratories and sort of compile all the meeting issues. In addition, if there is anything that's listed under the correspondence that you have not seen and wish to see, certainly reach out to the office or through the commission chair, and we can provide that information. So it's a continuing process, and I want to add also a number of people at the Office of Technical Services are involved in compiling this data. It is quite extensive because we do receive quite a lot of correspondence from the laboratories and from ASCLAD and the other training bodies at UNT.
So there's constant flow of this information, this data, and I don't recall in our meetings where proficiency testing was really presented in a formal way, so that when we're reviewing anyone laboratory's accreditation status, that in fact we have an understanding or appreciation of the laboratory and the analyst examiner's performance in proficiency testing. And that's why I asked the question, is there anything in here that we should be aware of that hasn't otherwise been presented to the commission?
As I said, that's why it's provided here to see if you see any issues. We have continuing issues that happen, but there's we have over probably 800 analysts in the state, and you're only looking at the only thing you see are any sort of errors, and sometimes they're not even errors, they're more transcription errors, or they're just a notification of an issue, of a problem that has to be corrected. So we have relatively minor, few errors, throughout the whole state. And as for repeated issues, we would like to bring some of these issues to the twig. If we see, let's say, for example, 2 or 3 labs failing a proficiency test exam, we bring it to the technical working groups for discussion on, maybe what the root causes of those are. But you're right that this is your one chance to see the PT information. Casework issues you generally do see probably more often in the commission meetings. And we're always trying to provide, if there's another way you want to see this information more quickly. We realize there's a lag between when we get this information and when you might see a proficiency problem that might happen in early 2012. You're not going to see until 2013 necessarily.
Certainly, in terms of the time to review this information, it is a lot of information. And if you see something in there between now and the next meeting, by all means, feel free to put on the next meeting. Anything further on the annual reporting? All right, if there's not, we'll move on to old business. Our first agenda item under old business is my understanding that there was an issue from the October 2011 meeting that was tabled regarding the New York State Crime Laboratory Advisory Committee and their position on complaints. There is a letter that was provided in the November 14th, 2011 letter that was in the materials outlining their position with regard to this issue. Dr. Corrado, I don't know if you have anything you want to add.
I don't think I do. I think we stated it clearly what our position. We were asked. I guess I would say we were asked to provide a position on this issue, and we did. And we're hoping that this commission and the OIG will discuss whether or not they agree with this or how they plan on addressing these type of complaint.
Is there any discussion on this item or on the letter?
Yeah.
Is that Barry?
Yes. We've had, there's a history here where we've had, many of us have received these initial complaints from whistleblowers and laboratories and turned them over to district attorneys, helped set up this whole process with the OIG, which I think has worked very, very well. We go into executive session and we've heard a whole number of complaints, some with merit, some without merit, right? Not, to my knowledge, there has not been one leak or one thing reported. If anything, there might have been some fair criticism of the commission, not about our executive sessions, but about even our public sessions, that perhaps we weren't as openly critical of what we saw in the crime labs to make district attorneys' offices, public defenders, and others knowledgeable about deficiencies that we saw from the ASCLD reports. So I really think that it is, in order for this commission to do its job correctly, we should really have knowledge of these kinds of serious or potentially serious problems, as they go to the Inspector General, so that we at least know or have an idea of what the range of complaints are, what their merits or demerits are, and the record shows that nobody has been slandered. On the contrary, I think what the record shows is that the commissioners have been extraordinarily protective. The OIG report seems to indicate perhaps too protective of the laboratory community, because we don't want to have captious criticism. We want to have, we want to encourage people to come forward with real complaints. So I think that there's no factual basis for trying to changing these procedures.
I'm sorry, Barry, as I read at least the first page here, it seems to be two separate issues. One, at least as I read it, looks at making a requirement that Dcjs forward all complaints to the Office of the Inspector General. And then the second deals with the amount of detail that would be given regarding those complaints to the Commission. Are you just addressing the second point?
I'm really addressing both, Mike, because it seems to me that while one agrees that Dcjs is not an investigating agent, an investigating body, it's part of the regulatory system here. And the problem with having all the complaints that Dcjs gets or the commissioners get independently from whistleblowers or anything not reviewed by this commission and the commissioners in executive session. We don't see these things before they go on to the Office of the Inspector General or any other body for investigation. Then we're not getting a real good sense of what's going on in our system, and we can't be effective regulators. We've never taken on the responsibility of being investigators. As a matter of fact, I think what we've done over time is perform very, very responsibly, in conjunction with various different district attorneys' offices. When something was of a nature that it had to be confidential and it had to go right to a DA, it did. If it was a more administrative thing, it did. There's been no leaks here, and there's been a lot of very, very sensitive subject matter discussed in these executive sessions. So I think if you're going to effectively regulate, you really need to get this information. It would be a real disservice to Dcjs if they just pass these things on without understanding where they came from and what the sources are and what the implications are for this commission as regulators and for Dcjs as the people that have to actually implement policy.
My point was, as I read the first bullet, the first bullet is a requirement that every complaint that Dcjs receives must get passed on to the Office of the Inspector General. And I'm not aware that there's any regulation to that regard right now. So unless there's something I'm not aware of, I think that would be a new requirement. And I certainly understand your point with regard to the substance of the complaints. I didn't know if you were speaking to the issue of the requirement that everything that is received by Dcjs be reported to the Inspector General.
Yeah, I think we're talking here, Mike, about this is the Coverdell requirement.
Correct.
In other words, and Chris Hammond is here, and she can talk to it because she was the first Inspector General that did with it. But, Mike, I think that what arose here is that there's the federal law that says that any instance of serious negligence or misconduct which can jeopardize the integrity of a laboratory result, there must be a body in place, an independent body in place, and a process to investigate those. Our independent body is the OIG.
As I read that first bullet, I didn't see it limited to the classes of cases that you just referred to. So maybe, Dr. Corrado, was it intended to be limited just to those classes of complaints, or was it purposely drafted broader than that?
Excuse me. It was purposely drafted broader in that the first bullet point was meant to say, not that the information could not go to the commission, but it was meant to say that because there was an issue where Dcjs started investigating something initially, or they weren't sure if they had to. We were making the recommendation that Dcjs forwards these complaints to the OSIG. So that was the first thing. Not speaking about, I agree with you that the majority of these complaints should also be brought to the commission. That was meant to be implied in that first bullet. The second bullet, which I think maybe is what we're talking about, what you brought up, Barry, were the particular complaints, and I think those of us on the commission know what we're referring to, where there were some serious allegations made, and there were a number of these complaints that were anonymous, and they were, in my opinion, a little over the top because some of them went to like personal issues, not relating at all to a technical issue with the lab, where someone says, I think that they didn't do this test right, or I think that there's someone dry labbing or something like that. I mean, some of those, I guess, could cross both sides of that. But I think that the particular people that, if a person in the agency, the personnel in the agency are making personal complaints, I think the lab directors feel a little bit that, whether or not the OIG investigates this and determines it to be unfounded, that information is still out there to a large number of people on the commission, as well as these are the same people that they have to come before the commission and answer other questions to. And I think on some level, maybe there should be some person, the OIG, that decides, is this something that we're going to investigate first, because it doesn't affect the integrity of the work, but maybe they need to still determine it's unfounded. And I guess we're looking for a little bit of those types of things rather than send them out, because it is people's reputation. Even if it's determined to be unfounded, it's still out there, and there's a number of people that have this information that, what are they thinking in the meantime? I don't know if that answered your question. I don't know if any other lab directors want to comment on that or not, if I said that clearly.
Yes, Dr. Chen.
Did ICLAC have a discussion with OIG in agreement with the proposed policy that all complaints essentially go through OIG for its...
We were asked at the commission meeting to provide our recommendations to the commission, and that's what we did here. We assumed that talking with the OIG would come from the commission. If they agreed with this, they would speak to the OIG about it. I mean, these were our recommendations to be discussed, and I assumed agreed upon here, or changed in some way.
Any other discussion?
I have one comment. Insofar that we don't know, I understand your concerns, Barry, about not having all of the information come to the commission, but insofar as complaints can be made directly to the IG, and we have no knowledge of those at all, I don't necessarily have as great a concern with just reporting to the commission that we have received a complaint regarding a particular lab that's been forwarded to the IG, and then they can get back to us with, this should be discussed with the commission at the next meeting, or information provided in the interim.
Well, there's been so many of them, some of which are, have real merit. I mean, I'm sympathetic to the view that there was, we all know that there was a series of anonymous allegations that were personal, that were unfounded, and that in and of itself became a subject of investigation by the Inspector General, and, who knows what happened to it in terms of some particular person being investigated or charged with bringing these kinds of baseless complaints. But, there's no basis for anybody saying that with all the years that these things have come before us, that this is anybody's been slandered. I mean, it just seems to me that what Gina, that's who made the comment, I can't see from these screens. Gina, then if everything just goes to the IG and this commission never sees it, that Dcjs gets as a complaint, it seems to me that 95% of what we've seen in executive session we would never see. And that's been very edifying, what we saw in executive session, because many of them have indeed become serious matters that the IG has investigated.
I'm not saying that you shouldn't see those in executive session, but the IG should be able to do an initial review and say, are these personal allegations about what somebody's doing with regard to their home life, or is it something that affects the integrity of work at the lab?
Many of these executive session complaints of a personal nature affect the work of the labs according to the people making the complaints. The dichotomy that you draw, a bright line between a personal statement and the work of the labs, is simply not there. On many occasions, for example, if somebody makes a personal complaint about somebody's conduct and says this person is engaged in X conduct outside of the office, but it could affect their decision-making inside of a lab, that's something we ought to see. I haven't seen the complaints you're talking about. I just haven't seen those. Every executive session complaint I've seen and participated in was either A, a substantive complaint, anonymously made or sometimes signed about substantive work done in a lab, or there's been a personal complaint about X or Y, and that personal complaint, usually the letter says, this is affecting how the lab is doing its work or being conducted. Now, sometimes those complaints have proved to be unfounded, and sometimes there was some merit to it, sometimes it was looked at. What is interesting to me about this discussion is no one can answer the question at NICLAC why, after all these years of doing this, there is not one case that we can turn to that says somebody's reputation was slandered, number one. And then there was the subsidiary question Dr. Carrata raised, which is, well, if there's somebody's reputation is affected by an accusation that we discussed in executive session, and the commission members know about it, that somehow when that individual, let's say it's a lab director, comes before the commission, that they will be treated differently in some way than if we didn't know about it. And unless somebody can point to an example of that happening in executive session, we can go into executive session now, and let's discuss whether that has ever happened at any session of this commission. I've been here since September of 2010. I can't find an example of it. I don't know of anybody who was questioned because we had heard something about them in executive session that changed the way we approached what they were doing when they reported to this commission. So it seems to me much ado about nothing. Finally, in terms of transparency, NICLAC's recommendation mirrors completely the exact modus operandi of Askclad Lab. Askclad Lab's modus operandi is a closed system where complaints are made to Askclad Lab. They investigate the complaint. If they find there's merit to it, they keep it to themselves. They don't notify the DA. They don't notify the defense attorney. They don't notify the complainant. They find whether the information is correct or not. If they find the information is correct, in fact, if they find that a lab has messed up and has exculpatory evidence that should be turned over to the defense, under the Askclad Lab complaint system, they don't do it. This suggestion mirrors the Askclad Lab methodology point for point. In other words, no transparency. Get it away from the public commission that has the authority to look into these things and hide it elsewhere, give it to another operating agency, and we may or may not get to look at it. There's no basis for it unless somebody can come forward and give an example that says there's a justification for bullet point number 2 in this letter.
Arvin, I think you raise a good point. Since I'm at a disadvantage here and I'm new, what I'm going to do is put this matter over until the next meeting so that I can go back and review the minutes of our prior meetings and see what type of issues we've dealt with. So thank you. I appreciate you raising that point. With that, the next item on our agenda is a discussion of the Inspector General's report entitled Investigation into the Nassau County Police Department Forensic Investigation Bureau. It's my understanding that at the December 2011 meeting of this commission, there was, first of all, extensive discussion on this issue. Secondly, I understand that the chair at that time requested feedback from various organizations, including prosecutors, the defense bar, lab directors, and others regarding that report. In connection with that request, letters were received from a number of individuals. Those letters are outlined on your agenda. I think there were a total of 8 letters received, and they've been distributed to all the commission members. So at this time, given the feedback that we've received, I would open it up for any discussion based on that feedback or based on the report.
Well, I have some comments on it, Michael, if I can.
Absolutely.
In many respects, the comments that were received by the commission pretty much mirror, almost to a T, the exact division that has troubled and almost paralyzed this commission for almost a decade. If you read the comments by the prosecutorial side, if you read the comments from NICLAC, you would swear that the Bibin report didn't exist, or it got it all wrong, or that the only entity in the world that can fix everything is Askeladd Lab. Now today we saw during the discussions of Nassau County precisely what the problem is. We had this long discussion about the case report, the lab report, which is the item that's introduced in evidence at trials and which is the subject of direct and cross-examination, versus the case file. And the real battle there, and why Ms. Hannaford, for example, resists this or wants all of the information in the case report, in the case file, and why lab managers around the state want this material in the case file as opposed to the case report, is because that way the information is hidden from the people in the court system. And these remarks that you find in these particular responses by the different organizations, with the exception, apparently, of the New York State Defenders Association and Dr. Benno, seem to indicate that here in this commission and the way the laboratories of this state operate is on this premise. We have a product. That product may be ending up in the court system, but we don't care. We want that product done the way we say it should be done. If this were the commission on science, I would agree with everything that NICLAC has to say. Because then you could have the battle about case reports and case files. You could have the battle over why uncertainty of measurement, error rates are not in lab reports in this state. You could have that fight between the labs of this state and scientific organizations. But that's not what this commission is. This is the Commission on Forensic Science. The product that we're talking about must conform and be amenable to the processes of the law, and particularly in criminal cases, because that's what it is. The labs do not want to do that. They prefer a system in which that does not happen. And the intersection of this is in these discovery issues. That's one of the reasons I think the labs want the materials in the case file. That's why the labs want it in the bench notes. And why would that be beneficial to the labs and not to put this information, as Mr. Scheck was trying to get out today, and Mr. Neufeld, into the test reports? Because if it's in the lab files, then the laboratories don't have to give over the file to the DA. The DA can then say to the court, I don't have it in my file, therefore I can't give it to the defense, and I can't give it over to the court. Or alternatively, if it's in the case file, but it's not in the test report, it stays in the province of the laboratory, and it makes it extremely difficult when it's in that file for the defense to get it. Notwithstanding all of the protestations of lab managers around this state who continually make the statement that I will give over, and I do give over, anything the defense asks for, that is not the case. The labs do not give this information to the defense. The labs see their customer as the police and the district attorney. And Dr. Benno, in her letter, hit it right on the head. She's going to be drummed out of the Corps at high noon. I'm absolutely sure of it. They're going to take away her sword, and they're going to break it in the town square. She clearly got it. She said, if I'm a neutral agency, I am the laboratory, I do science, then why is all of my information given to the district attorney? Why is it the district attorney is the filter? All the statute says in New York is, if the district attorney wants to use scientific evidence in a case, he has to give certain things over to the defense. If it's true, what the labs are saying, that they've been giving over material to the defense, obviously the labs currently are not abiding by 240.21c. And indeed, they are not bound to operate by 240.21c. This commission should take a look at the Bibin report, and in the name of transparency, it should say once and for all to the labs of this state that the product that they produce belongs to the criminal justice system, and that material must be released and given over to the defense upon request. And let me say this before we go any further, because there has been a great deal of false argument and misinformation around this issue, and it is this. No one would argue that if there's a continuing investigation or that there's material that's important to the prosecution that can't be released, that the material should be held up. There are protective orders that can be gained by the prosecution to protect that information, and they can go to court and stop the release of the information. Similarly, if you need this information, 99% of the time, there is no continuing investigation. Either the drugs are the drugs or they're not the drugs. Either a mistake was made in the lab and it was revealed to the defense, or it wasn't. Indeed, in this state, we know, as we sit here today, that there is no system by which mistakes made in the labs are reported to the defense attorneys, who are charged with zealous advocacy. And what is the answer to that? Well, the defense can cross-examination, and through cross-examination at trial, gain the information that they need. But in point of fact, as many DAs know, what good is cross-examination if you don't have the materials that you need to cross-examine upon, because those materials are in a case file that the labs have retained and refused to give over, or they've given to the DA, and the DA is refusing to give it over. So it seems to me that the remarks that were made here in these statements that we asked for ought to be taken to heart, but they should be given short shrift in some occasions, because all they are, in many respects, is the same old, same old. Final remark. There has been an effort in the last 5 to 6 months to change this commission. It is a determined effort. It is an effort that I think NICLAC's involved with, and to some extent the District Attorneys Association, and that is to change the very nature and character of the commission. That is to get rid of anybody who's an attorney and replace the entire commission with scientists. It was scientists and labs that got us into this mess, not defense attorneys. It was defense attorneys who got us the commission, not the lab directors. It was defense attorneys who, through their continuing efforts, have made this commission possible and stronger. It has been the labs and the District Attorneys Association that have combined together to try and make this commission something other than it is. So for all of those reasons, I would think, Michael, you have your hands full as our new chair. You've got yourself a commission which, for all intents and purposes, according to the Bibin report, although you wouldn't know this if you read the remarks from NICLAC and Dr. Corrado, all you would know is that the commission is moving merrily along and that Askeladd Labs' standards, its policies, its statements are the gold standard, when in fact the commission was told in March of 2011 that Askeladd Lab was a bankrupt organization, that it had been involved in major scandals around the United States, and that it was continuing to be thrown out of different entities where it had covered up major lab scandals. And yet, as we go from meeting to meeting to meeting, this is all report, and all that said is, we have to just do what Askeladd Lab wants. So it seems to me that the changes that we want to make need to be made. Bibin's report outlines them. They're clear, they're lucid, many of them don't cost any money, and we could enact them in a second. But the commission voted against enacting any of those reforms. And true to form, here we are 3 months later, and I guarantee you, Michael, no matter what your best efforts, this commission will continue to kick the can down the road by votes of 9-3 or 8-3, and will do whatever it can to prevent meaningful reform in forensic labs in this state. Thank you.
Thank you. Any other discussion? I see someone has their hand up, but I can't see who it is.
Yeah, it's Mary Luciano. I'm for the New York State District Attorneys Association. Our letter does not even mention Askeladd, and it was not in support of Askeladd, so I'm not really sure what he just said. But our report was, taking the IG report, our concern was that there be direct reporting to the prosecutions, the prosecutorial agencies on any significant errors. That was one of the biggest recommendations. We are very in favor of that. We don't want it to come from or wait until it comes up to CFS. We want it to come directly from the labs on significant errors and to have the lab directors responsible to do that. As to discovery, I would disagree totally with Marvin on this issue. It's not the first time. We believe the case file goes over. There is no one I know that was now taking the position that it does not. The reason it doesn't get filtered to the DA, it's just an easier way and a cheaper way to do it. The Westchester County Lab does provide discovery to defense, but you will pay for it, I assume. But it doesn't matter. We do not tell the lab not to give discovery. They do give discovery. So I don't believe that's an accurate statement, as that there is a plan to keep us hidden information. And our letter that we did submit on the District Attorneys Association was very clear that we think that the CFS is the best agency committed to the accreditation, not Askeladd Lab. So the letter that we submitted was in favor of a CFS, as well as the Office of Forensic Sciences to work with them, services to work with them. So I don't believe that was an accurate statement of the District Attorneys Association's position on this matter. The OIG report was very important in the fact that if these matters are going on undetected, it is very dangerous for everybody in terms of the case file. So we are very in favor of transparency in any way, and we supported those recommendations fully. We did not get involved in the earlier recommendations as to the Nassau lab itself. We kept our remarks to the latter recommendations because they were more general. We didn't enter into the fray on the Nassau because we really didn't have the standing to do that.
Okay, thank you. Any other comments or discussion? Is there a hand up?
Yes.
Wait, we have one comment here first, Peter, and then I'll give you the floor.
Oh, okay, I'm sorry, go ahead.
Becky Prince, Office of Chief Medical Examiner, New York City. I don't have it in front of me, but I was part of the group composing the response from NICLAC, and we did actually endorse some of the recommendations. So it's not very productive to discuss this as an all-or-nothing type document. It would be my wish to go forward here, to go over each recommendation one by one, discuss the merits, and decide on the recommendations one by one, instead of deciding on the whole report.
Thank you. Peter?
No, it wasn't me. It was Barry.
Oh, I'm
had a
sorry.
comment.
Well,
Thank you.
I would take Dr. Prince's suggestion to heart, Mike, if you want to proceed that way, and we could go over the recommendations one by one.
Is that a motion?
Yeah, I would move to go through the recommendations one by one. What? Well, and vote on them that way, yes. I mean, so the record's clear, we made the motion and recommended the adoption of each of these recommendations. I would suggest that we do them one by one.
I guess what I would suggest, given the time, my thought is that if someone else talking? Given the time, my suggestion would be if we're going to go through these recommendations one by one and have discussion on each of them, I think that's going to put us somewhere around 7 o'clock by the time we finish now.
Recommendation number 1.
So I do think that it's reading the materials that we've been given, I think it's a good point that we should address these one at a time. I know, Marvin, you said that these had all been rejected, but they were rejected. They were only voted on as a whole. I don't think anyone ever looked at each individual item. So I think it's a good suggestion, and my only suggestion would be that we do that at the next meeting.
I would second that. First of all, with all due respect to the Commissioner, this is your first meeting, and it might be helpful for you to maybe absorb some of the things that have been discussed in the past. And what I would simply suggest is that each commissioner, and this is not mandatory by any stretch, it's not a motion, but I would just suggest what I intend to do is I'm going to outline my position on each of the recommendations in writing ahead of time, so we maybe can save some discussion. Because Marvin is absolutely incorrect. There's, if you read the letter that Mary Ann alluded to, I think the DA's Association, and Murph and I helped draft that letter, were very accommodating to the suggestions, at least as they affected us. So I would suggest that we consider doing that, and that we take it up at the June meeting.
I do appreciate the suggestion of submissions in writing, and certainly anything that any of the commissioners want to submit in writing on each of the recommendations prior to the meeting would be appreciated, and I think might help move the discussion along.
And could I just add one thing? Dr. Jenny made a number of recommendations, and one, not that they all weren't good, but one that particularly intrigued me was the idea of working groups in the various subdisciplines, such as we have in DNA. So that might be very, very simple. And I'm talking about the meat and potatoes issues like toxicology, ballistics, firearms, fingerprint, and I think that might be some. I would like input, particularly from the other commissioners, what they think about that recommendation.
Do I see a hand up in New York?
Yeah.
Yes.
Chris Henson. I just want to respond to a number of things that Marvin mentioned. First, with regard to the laboratory's understanding of their obligation to turn over bench notes, recently every lab in the state has agreed to put a notice on their summary lab report that they do have additional documentation. That is put there as an aid to defense counsel to remind them that there is in fact additional documentation. That's being put on there despite the fact that the CPL makes clear that defense attorneys have that right. So I just want to make clear that the laboratory directors have taken a step to assist the defense counsel in knowing what there is available to them. Secondly, Marvin seemed to imply that no effort is made to alert defense attorneys to problems that are found in laboratories, and that is not true. I know in Nassau County, the entire defense bar and court systems were notified of what happened. I know in New York City, regarding the irregularities that took place there, we went to great pains to notify defense counsel of those matters, turning over to them vast amounts of material. So I just don't want it to be left said that we were not mindful as DAs of our obligation to let defense know.
Thank you. Any further comment or discussion? Is there a hand up there in New York?
Yeah, it's Barry again.
Yes, Barry.
Well, if we are going to take them one by one on another occasion, I would just try to limit myself to some general observations and try to focus on those things where I did see some agreement from the various different parties. First of all, it should be said that there needs to be more funding for forensic science. That I totally appreciate the idea that, continuing education can't be accomplished if people have too many cases, and that we should take advantage of all different kinds of technology here to have good continuing training. What I find troubling, though, in particular about, I must say, Dr. Ferrato's letter, and I don't know if this was issued by you, Doctor, on behalf of NICLAC, right? Or these were just your own comments?
Well, there's two letters in there. One are just my own, and the other is the letter from NICLAC. And it should be clear, the one from me is on my lab letterhead, and the one from NICLAC is on the NICLAC letterhead.
I see, okay. Just as a general observation, one of the things that OIG said, one of their strong recommendations is that there should be an appointment of somebody with a strong scientific background in Dcjs. The complaint is made that we don't have enough quote-unquote forensic scientists on the commission. I think that the better complaint is that we don't have enough scientists from academic disciplines that relate to the forensic issues, but do not themselves, actually practice in the forensic scientists or have a forensic science research agenda. In other words, molecular geneticists, people that do physics, right? Most importantly, statisticians, people from the sciences that should have something to offer to the commission to improve the forensic disciplines. I'm really speaking from, these are the recommendations of the National Academy of Science report. The problem I have, Dr. Pryor, with your letter in particular is it seems to be saying, look, all these disciplines that we have right now, the problem here is that we don't have the fingerprint experts looking at the fingerprints, or the tool marks on bullets people on the commission regulating themselves. The NAS report was exactly moving in the opposite direction. That the problem is that many of these disciplines lack a proper scientific validation. And the only one that has that validation is DNA. And that's why it does, in fact, have its own separate subcommittee. I mean, that's what the National Academy of Sciences said. And if anything could demonstrate the difficulty was in our discussion of the fingerprints with Nassau County. I mean, look, even the recommendations of the FBI, which, we tried, we had to move heaven and earth in order to get the FBI to allow its SOP to be delivered to the commission, and I hope every lab would look at it. I think it would be a very good idea, and it's been recommended that the commission extend its jurisdiction so that it can regulate fingerprints, and we shouldn't have the police department doing its own fingerprint examination. The history of this commission has shown that there are all these terrible errors, like happened to Bill Fitzpatrick in his last murder case on fingerprint examination. And there are a lot of work being done now by cognitive scientists and others to try to improve this discipline. The purpose of this commission from the beginning, the reason we have New York State accreditation, as the OIG pointed out, is that we should be trying to set better standards. We should bring more to the table than the lowest common denominator. Got to do that. And so it really, it would not be worthwhile. I wouldn't recommend to the governor or the legislature that they give any more money, to this, if it's just going to be the practitioners regulating themselves. The whole point here is to have independent scientists on the commission, to have independent defense lawyers, judges, prosecutors on the commission, so that you can regulate the forensic services to make sure that they're serving the needs of the courts, because after all, the courts and the citizenry are the consumers of this, and to make sure it's done right. And I absolutely resent the statements here that there are self-interested parties that are looking at all these different disciplines and don't understand them. Frankly, the good thing about being a lawyer is that you can actually present some of this evidence in court, consult with experts, and try to figure out some of these disciplines and consult with other experts to figure them out. And the problem here has not been, frankly, that many members of this commission don't understand tool marks on bullets, fingerprints, DNA, or any of the rest of it. That hasn't been the problem.
If you want to.
Yeah, I just want to say, I think what I was saying in my final comments there was similar to what Dr. Jenny said, that I think on some of these issues, when technical issues come up, and I think there's a lot of people on the commission that have very good input and insight. I think there's a lot of that. I'm just saying, when it comes to technical issues, just like we do with the DNA subcommittee, which is made up of both, as you said, forensic science, practicing forensic scientists, as well as statisticians and molecular genetics. I agree with that, to have other scientists on these subcommittees. It's made up of all of those people. We send our technical issues to the DNA subcommittee to have them look at the really technical things and then report back to us. And I was just suggesting that, as Dr. Jenny did, that's just another option. If we're not going to have all of the disciplines represented, experts in the disciplines represented on the commission, perhaps another way would be to set up smaller subcommittees that we could defer some of the questions to subject matter experts. That's what I
Right. I just want to be clear with you. I don't disagree with that. In fact, recommended it and supported it. But you put in here, there's a fingerprint subcommittee appointed that didn't even include a fingerprint expert. I mean, that's because we were demanding that somebody look at fingerprints because it's been so bad.
I know, but
we don't even have jurisdiction over it, and the lab community has not done one thing to implement the latest improvements in fingerprints, given all these scandals. And I don't understand how forensic scientists, prosecutors, or police officials can be satisfied with, for 1 second, when you have an inoperable AFIS system and you have fingerprint identifications that are so bad and so wrong that are screwing up your cases. And, frankly, we've been saying this now for 10 years.
Barry, you and I.
10 years.
Barry, you and I agree a lot about fingerprint analysis, and you're really criticizing the wrong person. I have a little more familiarity with Dr. Corrado and her dedication to the quality of fingerprint analysis that is done in her lab. And I agree with a lot of your criticisms, but they're directed at the wrong person.
I'm not directing it personally in any way at Dr. Corrado. I want to make that clear.
It certainly sounded like you were with your comments.
Okay.
No.
All right. I take your word. Let's move on.
All right, does anyone else have any discussion?
Just let me clarify this one thing, Mike, as a point of personal privilege. I don't want the minutes to reflect that I was attacking Dr. Corrado. I was looking at her letter where she was saying that the problem here was that that fingerprint commission was said. I was pointing out the only reason we even had a subcommittee to look at it is that, frankly, I was bringing it to your attention saying, look at what these other cognitive scientists had said. Now, to be positive about it, it was a great idea to bring Dr. E.T.L. Dror here to give a 4-hour lecture, which should have been, was it actually video conferenced? Every forensic scientist in New York State should have seen with Dr. Dror. That was an excellent, presentation.
I appreciate that you had him come in, and we sent almost our entire staff. We had to keep a person back to do the latent print analysis cases, but we sent our entire staff to that, and they admitted that it was, we're happy to go because they thought it was very good. So I don't think, I don't think that's the issue. Just to clarify,
I agree. We need more of that, not less. I just wanted to be clear about I agree with Dr. Jenny's notion about the subcommittees. The implication in your letter, right, is that we need more, quote, forensic scientists. I don't think we need more forensic scientists per se. We need more scientists.
In my letter, the implication in my letter about the quality assurance subcommittee looking at the latent print discipline, I said it that day at the commission meeting, and I stand by this. The issue I had was not with you setting up a committee to review the way latent prints were conducted in the state, in the laboratories, and how they were documented. I had no issue with that. My issue was the entire committee was set up without a single, not one latent print examiner on that committee. And my thought is, if you're reviewing these things and a question comes up, what are you going to do? It seems to me, at a minimum, you would want to have a few subject matter experts in addition to that committee. That was my point. I said it then, and I'll say it now.
Any comment?
Yes, Doctor.
I chaired that subcommittee who was charged with the review of those documents, and I have to acknowledge that there was outreach to appropriate membership for that review, but there was very little interest. In fact, we made no progress. That binder is still in my car. I carry it every day. But reaching out for members to go through those documents and to present recommended best practices, there was no interest.
All right, thank you. Any other discussion? All right, we'll table this till our next meeting, and I would be, I'd look forward to getting submissions from any of the commission members who want to give them to us on individual recommendations in the report, and we'll plan on going through them one at a time. All right, that concludes the initial part of our agenda. The next thing we have is an executive session item, and I need a motion to go into executive session to discuss matters that may result in employee discipline. Do I have such a motion? All right, do I have a second for that? Dr. Jenny? All right, all those in favor? Anyone opposed? All right, we are going to go into executive session. I would ask that anyone who's not a commission member leave the room, and we will call in one at a time anyone with the subject of the items being discussed in executive session. Now, actually, the first item is not. Yeah, no, we need you to leave for a minute because the first item is on the record now. We were in executive session. There was no formal action taken in executive session. And I think the last order of business on our agenda is our next meeting date. I misspoke a minute ago. It's actually June 15th, and it's in New York City. So with that being said, if there's nothing else, we'll adjourn.
Move to adjourn.
All right. All in favor?
Yeah, you got to record the vote, Gina.
Thank you, everyone.
Thank you.
Thank you to everyone in New York.